Good evening, everybody. My name is Francis DeYoung. I'm the Vice Chairman of the Planning Board. Welcome to the meeting tonight, Monday, January 28th. The Chairman, Muriel Kramer, is out. She's a little under the weather. She may show up, but at this point, I'm going to assume that she's not here today, so I will cover in her stead. The first order of business this evening is the continued public hearing of Buckland and Leonard Street. I assume I have to open up the public hearing. Elaine, correct? Mm-hmm. I have a motion to open up the public hearing.
So moved. Second.
So in the second, all in favor?
Aye.
Opposed, abstained, it is now open. Okay, so this is probably the third or fourth installment where the applicant, Wall Street Development Corporation, has come in front of this board. The first time was, I believe, on July 25th. And most recently at December 17th meeting. In this discussion, we're going to speak, spend a fair amount of time talking about way in existence. And I'm going to have the applicant come on up, Lou, if you would, and maybe just give a kind of a 2-minute overview. We also have here this evening, and I'll introduce Rebecca Lacey. She is town council from the areas in Harrington and Wellesley, so she'll also be able to speak this evening. So I will give the floor, Lou, to you.
Good evening, Lou Petrozzi for Wall Street Development Corp. As you mentioned, the last time we were here in December 17th at the last meeting, there seemed to be quite a bit of questions from the members of the board regarding the distinction between a way in existence at the time or prior to the time the subdivision control law was adopted in Hopkinton. And prior to that meeting, we had submitted a package of information, of documentation to evidence the fact that the way was in existence prior to the adoption of the subdivision control law. So from what I understand, the process is for this board to determine that the way, based on the evidence, is in existence at the time in 1953, and that would then make the property eligible for an A&R endorsement once the next step would be to determine the construction standards for the roadway to be built along the frontage of that property. So step one, I'm hoping that we can resolve that particular issue relative to the way in existence, and then move on to the next part of the process would be to establish construction standards based on our petition to construct the way to meet today's standards for adequate access and vehicle emergency access and that sort of thing. So, I did bring the information on that was previously submitted if the board would like to see that, but I think most of the information, I think you need answers to your questions above and beyond what I have to offer.
Yeah, so that's a good overview, and I think, you know, for the folks who are here and also for those folks at home, Lou kind of outlined, I think, sequentially some of the steps that need to occur, right? The first is to determine whether or not it is indeed a way in existence as defined by those standards, and I think 1953 is when that was adopted in Hopkinton. And that then starts the next step of the process, right? Construction standards with the approval of the A&R.
Correct.
Okay. Any initial questions from board members to Lou on what we're talking about tonight and things that we need to be able to discuss? And I'm also going to ask Elaine and Rebecca to speak in a second, but I wanted to kind of open it up to the board.
So, through the chair, I have a question. This is more of a process-related question for either Elaine or for our town council, but just wanted to see if you could walk through, if this is, if we do vote to recognize this as a public way, then what is the process moving forward? I know that, to Lou's point, it would then be up for potential A&R, but can you just walk through the process from that point moving forward?
Sure. And I'm afraid that this process gets into a couple pretty arcane legal aspects of the subdivision control law, so I apologize in advance, but the first thing I want to say, so The determination that you're being asked to make is very specific, which is, was Buckland Street a way in existence in 1953 when the subdivision control law became effective in Hopkinton? So you're not determining that it was ever a public way, and you don't have to determine, it doesn't have to be passable now, and they're actually, well, I'll get into whether or not there's any standard for what constitutes a way. We can talk about that later. But right now there's no, Mr. Petrozzi asked you to make that determination because that will govern sort of how things need to proceed. But that determination, if you determine that it was in fact a way in existence in 1953, that means he can proceed down a road that will, he hopes, ultimately result in a determination that approval is not required. So the steps would be determine that this was a way in existence, then approve the roadway, so, you know, if you find it suitable for approval subject to relevant conditions. And then once he constructs the roadway, he could come back and say, okay, we've met, you know, there are different ways you can qualify for an approval not required endorsement. And one of them is if the street providing frontage was a way in existence at the time the subdivision control law was adopted, and it currently meets the standard. Don't remember the language off the top of my head, but basically, you know, the board considers it currently suitable for access. So obviously that couldn't happen until after he actually constructs the road. If you determine that it was not in fact a way in existence in 1953, that would essentially mean that he would not in the future be able to qualify for an A&R. So he probably, well, I don't want to, he might want to then change direction and submit a definitive subdivision plan. So that's kind of the fork in the road that we are at now, and that's why. So even though, you know, the vote on whether or not this is a way in existence doesn't actually resolve anything in and of itself, it sort of determines the way forward. Does that make sense?
I think so. Okay. Thank you.
Elaine, anything else to add to that?
I have a question to the chair after she had her hand up first.
Just to be specifically clear, if we were to decide that it was a way in existence in 1953, that does not mean that we are necessarily suggesting that we would be amenable to an approval not required. That's no bearing on that particular decision about the A&R question. They're separate.
They are separate. I mean, it bears on it, but
Yeah.
it's like necessary but not sufficient.
Okay.
So yeah,
Okay.
there's no predetermination regarding the A&R. It's just you're deciding this one piece of the puzzle.
Okay, thank you.
Just to follow on with that, then how would we determine?
Hold on, David. I think
It's related to the question, though? The
I'll
mayor
allow
just
it.
asked?
I'll allow it.
Okay, thank you. So, if it is recognized as a way, what would be the determination criteria of whether an A&R is allowed or not?
Let me just read the.
Because to me, it was pointing to two separate things, so what would be the criteria for the second? Thank you for allowing that.
Okay, so, you know, there are three ways that you can qualify for an A&R, and the one that would be relevant would be if Buckland Street was a way in existence when the subdivision control law became effective, and you would have to find that it currently you know, down the road, when the A&R plan is before you, you would have to find that Buckland Street at that time has, in your opinion, sufficient width, suitable grades, and adequate construction to provide for the needs of vehicular traffic, blah, blah, blah. You know, so the steps are, you would determine, if you determine now that it was in fact a way in 1953, and you allow Mr. Petrozzi to go ahead and construct the road, then down the road, he could come, in the future, he could come back with an A&R plan, and you would have to just, and I mean, I guess I would say at that time, you would have made this decision, you know, regarding the way in existence. You would have approved the road. So, assuming that the A&R plan was in order, there probably wouldn't be anything else for you to decide, but we just, from a process point of view, we just want to be clear that the A&R endorsement happens at the time that there is an A&R plan, not before.
Right. So,
I'm
Frank,
completely confused, but I'll get back to it.
thank you.
Well, maybe my question will help. It seems reading the documentation and all the information you guys, both sides have provided, all sides have provided, a way in existence is a legal specific term. Did it mean something different in 1953 than it does in 2019?
Good question. The case law, so there is not any standard provided in the case law that interprets what it means to have been a way in existence, at the time the subdivision control law was adopted. Because at that time there was no subdivision control law, so there obviously weren't necessarily any particular standards about, for road construction. And look, just so it ends up being a fact-specific question that's not governed by a particular definition. It's sort of whatever the land court judge sort of considers is or isn't a way based on evidence before him. There's one example that I brought with me of a case in which they go through, various types of evidence and decide, even though it's kind of a borderline call, decide that it was sufficiently away. Whereas, so for 1953, it just would be a question of determining, I would say, whether, you could you in fact access the property with a vehicle at that time is the question. But then for the A&R plan, you will also have to decide, that's when you have to decide that currently, again, this is after Mr. Petrozzi improves the road, you'll have to decide, that it has in fact sufficient width, suitable grades, adequate construction, and so forth. But it could have been basically like a crappy little dirt road in 1953. That would be sufficient for that part of the.
So for clarification, if we find that it was a way in existence in 1953, then that would have bearing on future decisions, other decisions about this. And what I'm thinking of, there are three different scenarios that we're looking at, either approving that it was a way in existence and there are facts that support that or not. So one is that there are, second is that there are not, and there is, we have to take action on this? Or if we take no action, is it purely land court? Or the things that you were saying about the legal specific terms about a way in existence, we're offering guidance, not necessarily a decision. Is that?
Another good question.
Because the land court seems to hold that power. So whatever we decide can be brought to land court either way, anyhow.
Yes. So the thing that's tricky is what would be challenged in land court, or sort of under normal circumstances, it would be, you would sort of be making this decision all at once. The A&R plan would be before you, and you would be looking at, okay, is the road sufficient now, and did some form of it exist in 1953? And if you decide that, in fact, the plan does not qualify for A&R endorsement, and the applicant, brings it to land court, then the various criteria that were examined, all get challenged at one time.
So it only goes to land court if someone challenges a decision that you make. It doesn't,
Right.
the land court doesn't have any power aside from that.
Got it. So we need to make
So,
this
but this is sort of
down.
a little bit of an unusual circumstance where you're being asked to sort of make this decision a little bit ahead of time about the way in existence. I think technically, we might have to consider it sort of an advisory.
So maybe, you're
Decision.
giving guidance that you do, either you do or you don't consider the evidence to support what's been stated.
But I think I would advise that technically that your decision on that as part of this proceeding would not be challengeable and would just be, that it won't be set in stone unless and until you make a decision on the A&R plan. But again, the idea is you're just being asked to sort of be fair to the applicant by not having him go down a wild goose chase when it, if you, and do a lot of work to make a roadway and bring an A&R plan for you, and only then find out that you don't consider the evidence to be sufficient.
Thank you.
Thank you for that. So a couple things, just so I'm clear. If we were, as a board, to see this as a way in existence, Mr. Pedrosi builds the road, that would be a road from Pleasant Street all the way to the end, right? They build that out?
Yes.
Okay, so just be clear on that.
But sorry, can I just, one clarification is, just to be clear, those are two separate, way in existence is sort of just this hypothetical question. That's separate from his petition for approval of the roadway when you'll talk about the specific standards that you want and so forth, so.
That's okay.
Just a follow on to that, if I might.
Yeah.
It seems very weird that we, just by making this an existence way, we're giving him permission to go between those two houses and make a road.
Well, so actually so a couple things. One is, again, the way in existence is just sort of this hypothetical determination that has no specific significance right now. So the thing that gives him authority to actually do something is if and when you approve the petition for approval of the roadway.
He's got to bring the roadway in front of us now.
There's two steps.
Two steps.
Two steps.
I got that. All right.
And then that approval, if you grant an approval, does not convey any property rights. So you're just saying, you've convinced us that you have, per my advice, I've advised you that I believe Mr. Pedrosi has made a colorable case that he has rights to improve the roadway. But you're not adjudicating those rights. You're just saying, okay, great, to the extent that you have rights in that roadway, we authorize you to construct it, but to the extent that there's a dispute about property rights in the roadway, you go fight that out with the abutters, which actually they're doing in land court because there is a pending lawsuit to establish ownership and rights in the roadway.
Okay, that's helpful. I think one of the things I'd like to see next, and maybe Lou, you can do this in a kind of a synopsis, is present or at least articulate what the evidence that you and your counsel have brought forth to make the case for, yes, this is a roadway.
Sure. Well, as I previously had submitted to the board, there's a plan on record from 1946 that shows Buckland Street being laid out as a right-of-way from the frontage of the property out to Pleasant Street. But in order to document the way in existence, major criteria was we've obtained aerial photographs of the area from 1938 and another one from 1987 that show Buckland Street and Leonard Street to be existing in some form on the ground at those times. So 1953 being in the middle of those dates, we conclude that the way was in existence in 1953 based on those timeframes that we've provided the aerial photographs for. In addition, on the property or in the right-of-way are two utility poles that provided electrical service overhead. We've provided photographs of those, and we've also provided on the plan the location of those poles where they exist within the right-of-way. Those pieces of information are what we consider to be the most factual information to document the fact that it was a way in existence during that time frame. And as town council has stated, that it could be accessible by, a horse and carriage or a cart or path or whatever standard was in 1953, but we believe that information substantiates our claim for a way in existence.
question based on that.
Sure.
So Rebecca, my earlier question,
Let me just do this. I was gonna, if it's a question directed toward Lou, that's great. But what I was gonna do is I was gonna actually have Rebecca speak regarding those facts, and if there's any other additional information, and maybe ask her
sure,
her
okay.
opinion.
Then if she doesn't cover what I'm asking, then I'll tell you.
Perfect.
I do have a question,
Yeah.
directly for you. At our last meeting in December, there was some discussion about the aerial photograph that you had provided, and it having some, an indicator for Buckland Street, kind of like a little
Correct.
piece of paper. Were you able to provide a new photograph? Because at the
Well,
time we discussed you providing that. so
I
that
did
we could see
provide,
it.
I did bring with me a blown-up copy of that without any labels on it.
Okay, thank you, thank you.
Can we zoom in on that from a camera angle? Is it possible? Yeah, good.
So, this is, just to orient everybody to this is Leonard Street, Buckland Street, the property. This is a 1938 aerial photograph that you
For the
all can-
purposes of the camera, and therefore so everyone can see it, can you move the easel a little bit toward that wall? Because it's that camera that he's using,
She means also for the audience too,
for
but
the audience, yes.
It's behind you, ma'am.
Yeah, I know,
Okay.
but I'm saying for the easel,
So, as I was saying, Leonard Street, Buckland Street, the property is in this location right here. This is the 1938 plan. This is the 1987 plan, which all of this information is online, you can access it. Same thing, Leonard Street, Buckland Street. The property is in this in this area right here. So, we have other, these are the utility poles that are installed on the property, or in the right of way. There's two of them. And we've identified them and surveyed the locations of those poles. They're on the plans that we've previously provided. So the information is,
When are those pictures dated?
when did I take these?
No, so when did the polls, what's the date of the polls?
We had no idea. That's how far back they go. It wasn't, there's no recorded easement, there's no documentation at, what was Boston Edison before it was, the various names of what utility companies were back then.
And they're just poles, there's nothing attached to them at all?
Well, there's overhead wires attached to this one here, and there's nothing attached to these. Our guess is that at one point, these are the locations of the poles right here. And this pole provides power to this overhead electric, to this home at the end of Maple Street Extension. Based on the spacing and the location of the poles, we can only assume that the power came along here to service this house. This house has been here for over 100 years. Now the power for this house comes off of Maple Street Extension, and there's no overhead wires on that right-of-way at the present time.
All right.
Can you go back to the 1987 photo there? My question through the chair, so what constitutes a road there? So I definitely see I see some indication of something there, but I'm just curious as to
Well, if you're
what makes it a
familiar
road.
If you're familiar with the area, Leonard Street is actually constructed as a gravel roadway for quite a distance, probably down into this area here. These are high altitude area photographs, so typically the shading that you see here would indicate that there would be tree removal or something that you're going down all the way to the ground.
So just to clarify, so it's the shading color that leads you to believe that there is a road there in 1987?
This particular photograph shows it as a darker vegetated right-of-way. This here shows it more clearly that this is a path.
Yeah, I definitely see it there.
Okay.
It's just on the other one that I'm struggling a little bit, other
I'm just trying to
than
give
some
you
shading.
some context in terms of between periods. So this is 1938, that was 1987. It's the most available information that we have from an aerial photography standpoint. Now, there are other photographs. Some of them are taken at a different altitude and a different angle that don't show they're going down in an angle through trees instead of over above the trees. So different ways to get photographs, but these are the two clearest identifiers.
Just a request for the chair. I have
Question,
another
yeah.
question for town council. Can you just put me in the queue when?
She's on the docket.
All right,
She's on
thanks.
next. Any other questions? Oh, Carol, please.
I have a question. On the 1938 photo, I can see very clearly where you can come in off Pleasant Street to those two properties. From where I'm seeing it, I don't necessarily see a clear connection, and what concerns me is when we walked the property, there was a stone wall, to my recollection, that went across where that road would have gone in. And looking at this, I could see where just as easily you could have come down the other street and cut across the property to get to that T. So, do you have anything that would show me that it connects? Or is this
What connects Pleasant Street side?
Pleasant Street to Buckland? I can see where you could get into the property and traverse it for this section, but I don't necessarily see where the entrance to the two properties connects to Buckland Street going in.
Are you talking about the properties on Pleasant Street at the corner?
Yeah, right where your pen is, I can see it turning in,
Yeah.
but then there seems to be nothing until it kicks back out.
Well, this area here you're talking about?
The connection
Yes, but
between
at the
two.
back of that property, there was a stone wall that,
Right
to my
here.
recollection, would have crossed that road.
There could have been, there could have been, who knows what happened in the interim in terms of walls or stones or who did what there. Could have been a piece of equipment that moved boulders around, or it could have been any number of things that could have happened over there in the last 70 years.
Could it also have been that access was gained by going up the other street and crossing the property?
Up Maple Street Extension, you mean?
No, up
Leonard Street?
Leonard Street and crossing the property at that cross in the middle.
I couldn't tell you, but in either case, if we weren't here for Buckland Street, we'd be here for Leonard Street, so they both fit the criteria of a way in existence in 1953. So I could ask the board for a determination on both streets and then pursue the development of the property under those circumstances as well. So we chose Buckland Street because it makes more sense in terms of the possibility for developing and avoiding the wetlands on the Leonard Street side. That's primarily why we determined that Buckland Street would be a more practical use of the right-of-way. If this board determines that Buckland Street isn't a way in existence, then Leonard Street definitely is a way in existence.
I think the issue in front of us is Buckland Street
Street,
today.
correct.
Right, so we'll focus on that. If you could put up that photo, Jimmy, again.
Which
So
one?
that turn, the one you got right there, so I just wanted on the video. So that turn-in that you have that's bright white for Buckland, is that essentially right where you had?
This is a driveway that's there right now.
That answers my question. So it's a driveway that's not necessarily an extension of
Well,
what Buckland
yeah,
Street was.
we don't know what it was in 1938, to be honest with you. I mean, we're asking a lot of hypothetical, subjective type questions here. All we can do is provide evidence to substantiate what
Support that.
we're asking for.
Cool. Any other questions for the applicant directly before I'm going to turn over to?
Yes. I understand the process and the order that we're going through in regards to a way in existence. But one thing I think we're a little bit out of order with is when you're meeting with the Conservation Commission. So if you're not approved for 4 lots, will you be still pursuing this project?
Well, I think what we're trying to do on simultaneous tracks in order to get both boards to coordinate
Sure.
what the comments are and what the concerns are.
I know it's difficult.
So everything is taken into consideration when we ultimately have a plan. We are in the process of also including some other, I call it mitigation to improve there's a tremendous water problem there, the surrounding areas that we're trying to find some solutions for. And we're in the process of coming up with some substantial improvements there that include the development of Buckland Street along, with those improvements.
Through the chair, but your comments about Leonard Street, I think were totally out of order because the wetland situation on Leonard Street precludes any crossing.
No, it doesn't. Sorry.
So we won't go down the Leonard Street Road. We'll just kind of keep that.
You brought it up, and I think that's when you bring something like that up, it should be pointed out that that's out of order, I think. So,
Fair point.
so my last point about this is, if you were approved for, say, for 2 properties to be developed, would you still be pursuing this development project?
Do you mean just building 2 lots?
Based on the wetlands and the order of things being approved by a Conservation Commission and Planning Board?
I'll make that decision when we have the approvals or non-approvals.
Yeah.
I mean, there's the whole process involved with appeals and other things that we'd have to evaluate.
Probably hypothetical right now.
Yeah.
We
It was hypothetical.
We should go down the road. I'd like to, before the next step, I'd like to ask Ms. Lacy so Lou, I think we've got do we have all the facts from you, right? So the aerial photos, the utilities, the path, right? Is there anything else that I'm missing? I'm just trying to kind of look at all the facts that we have from your point of view, and then I'll.
I think that's pretty much what we've
Fair.
submitted, yes.
Yep. Ms. Lacy, based on the evidence provided and what you've seen, would your opinion be that this is a way in existence? Prior to 1953, right.
Right, so just to be clear, that
not
it was
now.
a way in existence in 1953. So I want to be careful that the factual determination is purely for the board to make, so I don't want to opine regarding the facts. So from a legal standpoint, and I obviously was not there on the site visit, which may have provided, relevant information. From a legal standpoint, I will say that you have to consider the facts that are in front of you. So if no one else has put forth, I do think a factual basis has been put forward, a colorable factual basis has been put forward to determine that it was in fact a way in existence in 1953. If you were to find otherwise, you just need, there needs to be some countervailing facts that you cite. It could be from the site visit, or it could be your interpretation of the photos or whatever, but I just want to be clear that right now it seems like there sort of hasn't been a counter argument put forth factually. The other thing I just want to note is the deeds and plans can also, in land court cases, those are also used as evidence. It's just one piece of evidence, because obviously you can have a paper street that's never actually laid out on the ground. But to the extent that there are plans and there are deeds over time that refer time and again to Buckland Street or Dr. Buckland's Way and so forth, that's also evidence that is fair game to take into account. So sorry to give you somewhat of a non-answer, but I just don't want to decide the facts for you.
That's fine.
This might be a good point for me to ask my question.
Please.
If I may. So, I know we shouldn't trust the internet, but looking at, I did a search on right-of-way access, and this McInnes Cooper site, which is the second one, comes up and says a private right-of-way typically gives one landowner the right to use another's property, usually a road of some kind to get to and from her land. Does that sound like a fair statement?
I mean, I just want to be clear that right now that question isn't relevant to the question of way in existence, so I just don't want to.
So right-of-way has nothing to do with way in existence?
Right.
I have a question about that too, David, if I can kind of,
Sure.
I've
have
been
more,
thinking
but
about how to word this too. I will cite the example that I am most familiar with. I lived in Detroit in a fancy neighborhood, well, for Detroit. And, well, anyway. But we had a shared driveway, we had a garage, but there was this really awkward little corner in back of our garage. And the family behind us would throw their trash in the back, in that little corner, and I would have to go clean it out. So after 7 years, they said that if I let that trash build up in that little corner, that would no longer be my property or my say. So my question is it, I'm trying to figure out how to word this, but is it really 1953 that we're looking at? And what is the emphasis, what weight should we give the use of right-of-way versus way in existence?
So the way in existence question is just a question of whether, and again, sorry for the legal minutia here, but that's just how sort of the law works in this case. The question of whether it was a way in existence in 1953 is literally just about what was on the ground. It does, for that particular question and that particular, criteria that you would later use in the A&R decision, it doesn't matter whose way it was, the property ownership doesn't matter at all. It's just literally, the question is like, could you travel down, in some meaningful way?
Physical, scientific, visual
exactly.
element.
Was it a little, some type of little roadway at the time? So that's, the way in existence question is only that. When you come to the petition for roadway approval, for that is where, the planning board, people can't come in and just willy-nilly file petitions to construct roadways, wherever. They have to demonstrate that they have some type of relevant property interest. They have to demonstrate that they, in fact, have the right to develop the roadway that they're proposing. However, the planning board does need to satisfy itself that, the applicant at least has a colorable claim of right to develop the roadway. But because, again, the planning board doesn't actually adjudicate the property rights question, that, plays out in land court, it's sort of a low bar. Yes.
But should we be adjudicating the 1953 example or the example of the property just prior to the ruling of what a paper street is in 1998? So the physical proof that we see over a progress of historic terms is that it's slowly disappearing. So this right-of-way no longer has electrical lines. It no longer has, this way of existence no longer has electrical lines. It no longer has a really significant access, So should we be doing it historically from the evidence from 1953, or should we be doing it from the time period just before it became, quote unquote, the paper street ruling, which would be just prior to 1998?
Well, so let me just say a couple things. One is you should, for this question, you should only be looking at 1953 because basically the question is, the way that the law thinks about it is when the subdivision, everyone sort of had certain, things were in a certain state when the subdivision control law suddenly came in and kind of changed everything. So the idea is certain determinations trace back to that time, because the idea is if someone owned the parcel at that time, and had some type of right to drive a little, or had some type of, ability to drive a little car down the road, then they had some kind of meaningful, right to a lot at the time that the subdivision control law came into effect. And so that's what the 1953 question is sort of what was the state of things when the subdivision control law came into effect. The 1998, what you're calling paper street determination, that might be, is that just like?
Is it 98? It was 98 where we weren't going to develop paper streets anymore, and they were.
So I don't, that's not
That has,
germane right now. I want to kind of focus on the question.
Rebecca, I never really got my question.
You know what,
answered.
David, I'm going to kind of hold that for now, because I want to be able to, I think we've been able to kind
I
of
did have a
get the
burning
facts.
question, though. Sure. Go ahead. So, the point I want to make is, we'll come back to the discussion right away versus way of use. But for a right of way, a person, that's in their deed, correct? That's in the deed that's on the property of the owners of the property, the right of way.
Not necessarily, not necessarily.
Okay.
Because
Could be.
there's the derelict, right, it can be.
Okay.
But we have this thing, the derelict fee statute, that is kind of what is offered here.
To me, in my proper mind, it would be in the right of way. So the person, if you have two houses, they give an owner access to their property, right? That's the way I interpret a typical right of way. And according to the internet, that's what I understand as well. So in that situation, one person is given a right of way to another owner. And if that owner then decides to build 100 houses back there, that almost seems like that right of way is null and void, because it's not just for that owner to get access to that property anymore. Now, said, okay, you can now build a street if you want to. I'm just trying to understand.
That's a good question for a law school exam, and I think I may have had to answer a question like that in my property class regarding the scope of an easement. So, how best to say it? The answer to your question is complicated, and I wouldn't want to answer it in the hypothetical. And so I think when we get to the point where ownership matters, I would want to just talk about it in the narrow way that it matters, it applies here, because.
And I'm fine with that. I just wanted to make a point. That's what I envisioned it.
That's fair.
The problem is that here, let me just say one thing. The problem is that here, we're not dealing with an easement. We're dealing with the operation of the derelict fee statute. Again,
Right.
another
So that's one thing I'd want clarity on further. It doesn't need to be right now, but what's the difference between right of way and?
Right now, we're talking about way in existence
In 1953.
in 1953. Thank you, everybody. What I
Fran,
would like to do is, oh, I'm sorry.
can I just ask,
I'm gonna ask you to hold it, okay? What I'd like to do is, we've had facts from Lou. I'd also like to open it up to the general public and look at other facts, maybe for the counter argument. Mr. Barbieri, I know you raised your hand, and maybe just introduce yourself. Please take a seat and provide your information.
For the record, Peter Barbieri, attorney Fletcher Tilton, on behalf of the mayors and the Longbrookes who live at the intersection. We disagree with the concept that was just noted that access is provided to this parcel. If you look at this plan in the comment that was made before, there's something through here, but the title to all of this land, including the deed that created this piece as its own separate piece, granted a right-of-way along Buckland.
Off
And I
Leonard?
agree
You
with
mean
the
Leonard?
point that if you look at through this area here, there is no access. And the point that was made before is that, in fact, all the plans of Buckland, even the one created by the Wall Street's predecessor Untitled, show a wall on the edge of their property with a small gap. If you go back to that 47 plan, not a gap big enough for a car or a vehicle or something else. And again, I think if there is access, it was back out to Buckland, back out to
Leonard.
Main Street.
You mean Leonard.
Excuse me, back out to Leonard and then back out, which is this route.
Yeah.
There's no connection in access through that portion or what is alleged to be Buckley and a way in existence. So I don't think at a minimum there was a way in existence through that point providing access to this parcel.
But you don't
You
know.
go back and look at the
And-
plan, the wall is there.
But you don't have any information to.
I'm just looking at your plan.
Yeah, okay, I just want to make sure.
Right, but are there any facts, right? So that's kind of a little bit of an interpretation, that, as I look at,
I don't know if I'm gonna pull up the 46 map that has the stone wall across the.
across the road, right? So I don't want to look at anything that
And
folks can't
that's
see.
my
But it's in our
comment.
packet.
Okay. I'll open it up to any other members of the public that'd like to speak and provide any factual information that they may have. Mr. Terry, please come forth and state your name and address.
I'm Thomas Terry of 17 Maple Street, and I'm in a butter to the west. I'm more concerned about the water going down there than anything else. But I can throw a little bit of light on the subject that we're on right now, because I was born in '36, and in 1953, that was complete jungle down there. And the lines that you see going down that have been alluded to as a road were probably a stone wall. There was a Buckland Way. I can remember my father talking about, but there was a Buckland Way. There's definitely a way, and went all the way down. Went down. The people that lived in the center of town used to go down and get their water that way. They used to go all the way down. There's a spring down at the end of my fields, whereas the railroad bed goes up now, which is now the trail, where that culvert is there. There was a collection area there where the people in the main street of town used to go down with their buckets and get water with their oxen and horses back in the 1850s. That's what, my father was born in 1889, but this was hearsay. And to get back to the property, could I just have that shot brought up of the
53?
aerial for 1938?
Mr. Terry, I think it's up there. I think that's the one up there right now. The one that you're looking at. Now, if you could, sir, yeah.
Thanks.
Yeah,
This is Leonard. This is the property we're talking about.
yeah.
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 Okay. This road is Maple Street Extension right now, and that comes in and serves that house that's here. But there's a little street right here where the two, where we're talking about, where Buckland Road is that correct?
Down further,
It's down further.
further down, move your pen down.
Down here.
Nope,
Okay, no.
nope, south. Keep going towards, right,
Keep
keep,
going.
no, the other way.
Down.
Okay, this is Buckland.
Yeah,
And this is the Wall Street property.
yes.
Right, this is the road now, it's a driveway right now. But we looked at the pictures, and it was alluded that this was to be a street. Well, that looks to me like it was a continuation of a stone wall. And this land out here, the history of this property back in here was where the two houses are built right on this side of it now. There used to be one house there. And that was built by a fellow by the name of Lockhart, who came out of World War II and built the house. It was a vacant lot previously owned by my grandparents. In 1860, they abandoned it because of a fire. So it sat until after the war that Mr. Longcraft came out, and he built the house here. So this was in 1940, let's say 45 or 46 or something. And then since then, Paul Elder has put two other houses in. He's knocked that one down and put in two. But this area here is the old road, and this is the street that goes down towards Maple Avenue. And they meet down in here where this house they're talking about. And there's a telephone pole here that services this house now. And this other telephone pole that you have in here, and this is probably at least 150 feet between these two telephone poles. Neither of this telephone pole in here, I noticed on one of the shots, it was kind of intimidated. There was wires leading to it in front. Well, that pole is a standalone pole down in the middle of nowhere. And if they ever led up to any wires to this, it certainly was way prior to 1953. So all I'm saying is this area here was never a way. And I was 13 years old when we were taking hay out of these fields back in here in those days. And this was just jungle back in here. And there was never any street passage, car passages or anything in 1953. So when zoning came in, I don't know enough about ways to determine whether or not this is a way or not, but in my opinion, it probably was a way. So does that make it always a way? It does, you have a good eye. If it had been abandoned, it's another subject. Definition of a way has 2 million different opinions that I've heard of in my discussions. So I just wanted to enlighten the fact that this area here is definitely not used prior to 53, or I'm sure, by looking at it, at least 20 years before that.
So Terry, how did you bring hay out from your back lots? How did you bring hay in and out?
Up Leonard Street. We had the car road went down, goes all the way to the railroad tracks. I have a 30-foot right-of-way that goes all the way to the railroad tracks. There's a stone wall on the right-hand side. There's 3 stone breakage points where we came out of those fields. First horses and then tractors. And then it's just a nice field now. Yeah. I just want to throw that out there about the way. I still think I know it was a way. And does that make it always a way? I guess the attorney could probably help with that. Thanks.
I'm interested in that question as well. So the pictures we see are not from 1953. If it was a way before 1953, is that the standard of determination?
The question is just what was on the ground in that moment in 1953. So if it had been totally abandoned and was like impassable as of 1953, it would no longer factually be considered a way.
Okay.
So we have the aerial from 1938. We have a map from 46, I think. That's helpful. And we don't have anything closer to 53, right?
As far as I know.
Well, if you go...
I would love it if we could look at the 1946 map on the screen, too.
Excuse me?
There's a 1940, I don't think you have it here. It was in our packet, though. Plan of land belonging to Michael J. McManus.
This is on the left.
Oh, there it is. That's it.
This is the 1946.
Yeah, that's helpful, too.
So the 1938, the 1953 is only, what, 17 years.
Okay.
So, the likelihood that would be overgrown or not passable or not maintained during that period of time, especially since in 1987, 34 years later, it still appears to be passable, so, or still appears to be in existence. So. What's shaded in pink here is the sewer plan prepared in 1989 that showed Buckland Street as a through street, going from Pleasant Street to the edge of the property.
So it wasn't at the site walk, but on this plan, it shows a little stone wall across the opening, right at the beginning. Is that what you used?
In 46, right? So if you were kind of scan back on the 46.
46 shows a little bit of a stone wall here, but an opening. There's obviously, even if you want to rely on that particular physical aspect of that's shown on the plan, there's still sufficient area for traffic or access to get through there.
Fran?
Yes.
I wanted to ask a legal minutia question.
I'm all about that.
Back to precisely what constitutes a way in existence? And particularly, does it constitute, the entire length of the way that would be needed, to access this property?
Both good questions. So unfortunately, as I said, there isn't a clear standard or definition for what it means to have been a way in existence. But just based on the fact patterns of the various cases in which it was found that there was a way in existence, I would say, if it was passable by the mode of transportation that existed at the time, if people used it, to get back and forth, in some meaningful way at that time. I mean, I guess in the 50s, it's not the case. It seems to me that you would need to have a vehicle be able to pass. I mean, a footpath in 1953, I don't think if something was clearly only used as a footpath in 1953, I think the court would not consider that to be a way. But again, it's not, it's just sort of, each case is sort of like whatever the judge thinks based on all this whole assemblage of facts. So it's hard for me to articulate exactly what the dividing line is about what is and isn't a way. The next question is, it would have to be, what has to have been the way in existence is if Mr. Petrozzi comes back here with an A&R plan and says, okay, here's the frontage that I'm using that, I'm saying makes this something that can be endorsed as approval not required, that whole frontage and access all the way out to, the street that you use to access it, that whole length would have to have been a way in existence. So
the entire length would have to have been a way in existence.
Yes.
As of 1953?
Yes.
Yes.
From Pleasant Street.
So passable through normal means of transportation at the time. And, so not overgrown to the point of being impassable.
Right.
Okay, thank you.
So Fran, I have a follow-up question to that.
I'll allow it. We have 5 minutes left.
I'll be quick.
So I want to.
The public though, too.
Yeah, I'm gonna, this will be the last one.
So Rebecca, we heard that in 1850 it was oxen used that path at one point, and and there's a doctor that lived down that path, which is why it's named Buckland. We heard that by 1953, the time of the subdivision bylaw, that it was overgrown and not passable, and moving hay from those back fields was just done on Leonard Street, which is further away from downtown, which means there's a little bit extra work. So that's 1953, and that's what we need to look at. But my question right now is, in 2019, isn't it kind of a bottleneck for today's standards of having a swipe path fire department to get back to 4 new lots? The 2 homes that are there right now, there are setback regulations that we need to consider as well, and I don't see a new street fitting in there. There are facts that...
Let me just interrupt you, because that will be the next step. That's when you talk about, should we approve this as a roadway,
But
that you can consider things like that.
Sure. But a way in existence in 1953 could be a walkway, not necessarily a roadway. That's the distinction I'm looking at.
I wish I could give a clearer answer because it's not super clear from the cases. In my opinion, a walkway would not be sufficient.
Right.
Because this, you're talking about needing to access a part, your property. But I can't point you to a case that says a walkway is not good enough. But
Sure.
Thank you. I'd like to, in the last few minutes, I'd like to open up the floor to members of the public. Any comments, questions? Mr. Terry, thank you for your perspective on that. I think that was very helpful. But I want to give the audience some time to ask any questions that they may have or make comments as that they deem appropriate. If you would, you want to come on up, just state your name and address, and so we can hear it on the microphone and see it on the TV.
I'm Rosie Saunders, 7 Prestwick Drive, and I actually own the property at 12 Maple Street Extension, which is in a butter at the end. It's at the end of Buckland. And I just wanted to just make a statement that when I bought the house in 1983, Buckland Way looked like a forest. So it was not anything that was used at all, and it was quite wet and overgrown. And I wouldn't say there were large, huge trees, but there were moderate-sized trees there. It was nothing passable in 1987. So that's all I wanted to say.
All right, very good. Thank you. Any other members of the public?
Hi, Linda Conley at 56 Pleasant. I just wanted to comment on the telephone pole that is behind the stone wall abutting my property. It's a very ancient telephone pole. You can barely tell that it's a telephone pole. Now has bird feeders on it. I don't know, I can't imagine that. I just wanted to say it's very old and decrepit. So I can't give it a date, but it's, I would doubt it was from the 1960s or 1950s. Thank you.
Any other comments from the public? Gary, you
Can I ask one more question?
absolutely ask a question.
I'm just curious, so in reading the memo that you provided to us, you had stated that in our opinion, Wall Street has provided adequate evidence and legal analysis to support its claim of rights to use and improve the full length of Buckland Street from the property to Pleasant Street. And so I won't get into the details of this memo, but my question is was the drawing from 1946 that shows a stone wall across Buckland Street, was that considered in your recommendation that Wall Street has provided adequate evidence and legal analysis to support its claims of rights to use and improve the full length of Buckland Street?
The short answer is that the existence or not, the presence of what might or might not be a wall in that area isn't very material to that legal question. So that memo was about, the next question that you're going to be addressing, or was pertinent to the next question. And the derelict fee statute, now that gets sort of away from facts on the ground and just into property boundaries and so forth. So the existence of that wall isn't super material to the question of rights in the way. It may be material to the question of way in existence. But again, I don't want to speak to the facts regarding that.
Okay.
Could you just repeat that, just kind of in a quick 30 seconds?
The existence or non-existence of that little wall that might bar the path, travel along Buckland Street, in my view, that could be material to the determination of way, was it a way in existence in 1953, depending, if it impeded, in your view, it impeded travel, made travel across the whole length of the way impossible. When you get to the next phase, and we're talking about rights in the way, the presence or absence of that wall is actually not that relevant to that, because we're just looking at property lines and deeds and so forth.
But with regards to way in existence, which is what we're debating today, that would be relevant.
Yes.
And then I'm also just so that was not considered in your recommendation on that memo from November 30th, because that was a different topic.
Yeah.
And based on your definition, if there was a stone wall across that pathway, whatever it is, in 1953, then by your definition, this would not be considered a ways in existence. If a vehicle could not drive through because of a stone wall, then that would not be a ways in existence.
I would agree.
So is it, through the chair, following up with what Gary is saying, is it possible for us to request another ruling based on new evidence?
I think we need to decide, right?
So
I think
the determination of facts is the planning board's decision. Right? So we have their legal opinion, now we have to make our determination.
Their legal opinion is contradictory. No, we just found out.
I think it's
No, because their assessment was a different debate than whether or not.
Okay,
this
so we
is ways in
shouldn't
existence.
consider that for this decision then?
So I'm going to do this, right? So just given the time, I'm going to open up, I'm going to pause, help me out with the legalese. I want to pause this meeting. I want to kind of open the public hearing for 52 Spring Street. That's regarding the stone wall removal, but then I want to come back to this because I'm going to poll the people here on the board, but I think we've got all the facts as it states, as it's been stated, both pro and against. And I think it's our responsibility to make a decision on this.
Can I have one more item? Because
We just have to open and continue.
Just let me open up to continue the other one, and then we'll get back to it.
Take a vote to open and continue
Yeah.
the public hearing.
So I'd like to take a vote to open up and continue the public hearing for 52 Spring Street
Until, continue after this.
after we finish up the conversation with this.
So moved.
Make a motion on that? Second. All those in favor?
Aye.
All those opposed? So passes. Okay, so we've got that. Let's go back to this conversation, all right, if we may.
yes, just very briefly, again, Christopher Simpson, here with the applicant Wall Street Development Corp. So it seems like there's a focus on this wall that's on the plan here from 1946. If you see, it clearly doesn't, at least on this plan, it doesn't show it going all the way across and blocking traffic. In 1956, in cases that I've seen from that vintage, they do mention two-wheel vehicles as being vehicles that might be utilized on such a roadway. And that's sufficient, that type of vehicular access is sufficient for you to find a way in existence. I just want, I can see, I hear what some people are saying, and I just want to make sure you understand, this is not a road that's blocked, a road that has, if you're saying that this 46 was in existence in 53, it's not blocked. It has vehicular access clearly by two-wheel vehicles. Who knows if anyone moved that, and there's more vehicular access than that. I don't know what that distance is. I can't tell you. I just want to make the point that case law does say that, for instance, a motorcycle is a vehicle that could be something that would access a way, and that would be sufficient. I think there's a low bar here that you guys are looking at in terms of what is a way in existence. It just has to not have been completely impassable at that point in time. Thank you.
So I'm good with approving a road for two-wheel vehicle access.
Okay.
Point of order, please. I'm not sure, you're one of the attorneys?
Yes, sir. I'm attorney with Wall Street.
I have a question for clarification. When you say two-wheel vehicles, are you talking about a wheelbarrow, a bicycle, or a cart, a hay cart, or something like that?
I think any of those would be sufficient. I mean, the case that I was reading earlier today, I can't give you the specific site. I could get it if you wanted to,
Sure. In general.
But it specifically mentioned two-wheel vehicles being sufficient.
And what,
If there was
final question,
access for that.
the 1945 chart you were looking at, how wide is the width of the opening that you're presenting to
So it
us?
shows the road being 30 feet wide and the stones,
Show distance.
That I can't tell you.
and the stones come at least 2/3.
2/3, so
across.
yeah, so you got 10 feet. It's a fair assessment.
I'm good at the law, but not at,
No, I just want to be clear through the chair that that was sarcasm that I said that I'd be okay with approving a road for two-wheel vehicle access.
Okay, understood. All right,
Is it possible to call Mr. Terry up again? Because I think historical, verbal history is very, very strong, and especially since he grew up there. I'm just wondering if he could come back and address and talk to us again. I'd like to just hear it again, his recollection of how wet that road was and they didn't use it, or how wet that way was. I just wanted to kind of get a sense of whether it was ever really even used at all.
Sure,
Whether it
but
made
I think he stated that it was used, right, as a way
Okay.
for different
Okay.
things. I'll allow a couple minutes, Mr. Terry, just to clarify, if you heard the question.
Well, Mr. McBride is sitting in front of me, and he's a couple of years older than me. And he lived in that area. And he farmed that area just like our families did. He's willing to talk. What was the question again, please?
So I had a question, because you said you did talk about your dad talking about it as being Dr. Buckland's way. So was it something when you were a boy that it may have not been overgrown? Or was it always, like from when you were 7 years old, was it always overgrown and never used?
It was always overgrown.
But your dad, there was a verbal understanding that there was somewhere in the woods that were overgrown, that something that was called Buckland Way.
We used to call the two fields that I own down there now the Buckland, because they were owned by a guy by the name of Buckland, and that's how that road got its name, Mr. Buckland. And my father bought, in those days, they were buying those lands for, around the 1900s for woodlots. So he bought that from, it was originally a Buckland property. And so we used to call that the Buckland down that way, down the fields. But as far as the road, there was always kind of like a old story about there was an old road down there years before my time. And when I was 6 or 7 years old, we used to keep young heifers down there in the summer. We used to go down in the pickup and bring water to them 3 or 4 nights a week. And I can remember being down there at 5 or 6 or 7 years old very clearly. And this road was absolutely impassable.
What year was that?
Probably 1943. So we used to cut hay on the field. The field that's down there now is cleared, and there's another field that's all overgrown. We used to cut hay off of both of those fields and haul it back up to the farm on Hayden Row Street. So that area down there, I may have misled you by saying Buckland Road. It was spoken of as a way as to how they got down to to get their water. I don't think it was ever service. I don't think the service ever went to that house down there at the end of Maple Avenue. I don't know what the telephone pole in back of Linda's was. Like I said before, where the two houses are now, as you go in off of Pleasant Street, they'd be on the right. That was all one lot, and Mr. Longcar bought it after he came out of World War II. He was an injured veteran. He built the house there. He bought that property from some relatives of mine. And so it had been vacant for 50 years at that point, according to family stories. So I can't give you any more facts than that, but I can give you what was kind of generally known. I think Mr. McBride could talk to you too. He was very involved in this. He lived right 100 yards away.
Mr. McBride, would you be willing to come on up? Thank you, Mr. Terry.
I'm a little older than him, so I remember a little more.
Your name and address, sir.
In 1953, there was nothing that traveled over that road. And in 1953, I was 19 years old, and I lived in 7 Leonard Street. So I was playing in there all the time, that area and down. Tom was talking about the haying. I used to go down when his father used to hay with horses down there, and very familiar with the area, and it was never traveled on at that time. Now, I don't know why the telephone poles, I imagine, might have taken electricity down for something, but not in that time. Thank you.
Thank you very much.
May I ask one question?
Oh, Mr. McBride? Question?
When you say there weren't vehicles going on at that time, was it still a surface that you
No,
could
you couldn't
traverse?
drive on it, it was all overgrown.
From the sides or coming up from the ground in the actual
What do you
way?
know that grows sideways?
Oh, I'm just asking the question
It
because
came up from the ground.
Because when I look at this 38 plan,
That's good. Thank you, Mr. McBride.
1938 plan, you can see that it doesn't, it appears to have, it doesn't appear to be overgrown to the point where you can't pass it. At least that's the way I see it.
What's the year on the other side?
That's 38.
That's
That one's
38.
38.
And what's the year on the flip side?
87.
87.
87.
Is it possible,
As of 53.
As of 53.
So,
I'd like to,
hold on, I got competing ones. Gary, I'll let Gary go first, and then Deb.
through the chair, and, I mean, this is, I'm not even sure who to ask this question of, but I think of, off of Chamberlain Street, there is a house that is, how to describe it? So you have Sanctuary Lane that loops around, and there is a single-family house that's built, and the driveway of Sanctuary Lane is actually a right-of-way across that. But the reason I bring that up is that the power lines, they actually cleared a pathway to put in the power lines, and in that case, the sewer line, which from above would look like a clearing in some capacity, but yet there is no road or anything remotely close to a road. And I don't know what that is, and I don't know, maybe it was a road, maybe it wasn't, but it's possible for something to have shading from above that in no way constitutes a road. And again, I don't know what it is, I just...
I mean, everything that I've heard, Mr. Chairman, everything I've heard tonight is, basically kind of self-serving statements. We've presented factual evidence of what we believe supports our position relative to a way in existence. People who talk about stories and things they may recall, they might recall when they were playing, when they were 7 years old. I mean, I just don't think that that's a valid method for discounting our request.
So if I may, through the chair, I mean, my understanding is that it's your job to prove to us that a road exists?
Yeah, I think we've done that. I think we've done, you're in the process of trying to talk your way out of it by saying, oh, well, they could have done this and they could have done that, and it's a shadow, it's this. Well, this is what people use today, in today's technology, to determine the existence of ways and structures and what the conditions were on the ground at a certain period of time. For you to sit here and discount it because it doesn't fit what you might think is the situation is not, I don't think it's fair to us.
So, sir, I don't think, I'm sorry, I can't say that.
Yeah, so,
Seems like continuing.
Mr. Applicant, Lou, what we're trying to do is look at the facts, right? We're not necessarily trying to fit in any particular model. So I will ask the board members for further, if there's further discussion or things that we want
Can I
to.
just make one comment? Testimony of witnesses who, if you believe their testimony, they're testifying to facts that they observed. That, I just want to say that is evidence that you can use, if you believe their testimony is credible. So I just wanted to clarify that.
No, that's helpful, right? Because I think it gives people a full context of, an assessment of the situation. Now it's really up to the board members to, make a decision on this. So I'll first kind of open it up for any further discussion from board members. And then what I'd like to do is I'd like to actually have a vote on this evening.
so this is just
Discussion?
one more point. This is discussion point, and I wanted to point out to the rest of the board two pieces of information in the factual diagrams that have been presented to us. On page 27 of today's packet, which is part of the site plans for this development, it's sheet 2 of 9 of the site plans. There shows on this plan a stone wall partially blocking the indication of the Buckland Street, and that partial stone wall that crosses Buckland Street on today's plans from the developer is the same as, visually the same as the diagram from 1946 showing that partial blockage. My interpretation of these two pieces of information is that stone wall has blocked a part of the Buckland Street Way from the time period of 1946 to today, based on those two diagrams, those two plans. Whether or not that is sufficient blockage to not make it an existence in way is up to each of you individually. That's it.
Should we go around to everyone, or do you want to?
For this, we can do a straw vote, or Elaine, is there any process that we have to follow in terms of this vote? Is it can I do a straw vote for people, or just do a straight up vote?
I think they should vote, but it's fine if they want to do a straw vote.
All right, let's just do,
Be a motion and a vote.
all right,
I just, if I could say one more thing. It is factually important to me that the evidence support the date of 1953. And for my purposes, that what I have seen put into factual information and data, including what you point out, Mary, does not support a way in existence in 1953. I just want to make sure that I say that.
okay.
Point of discussion.
Discussion?
I want to lay out my understanding of some of the facts. The pros on this is, from what I see, and there are facts on both arguments, but I think the reason that it would be a way in existence would have been the fact that the house that was built in the 1940s was built in line with what would be a street that wasn't a street. Historically, there was a path in the 1850s that Mr. Terry's told us about, and he's told us about historically there was a doctor, Buckland, that's what it's named after. But as far as a paper street being Buckland Street, it was not a passable, so those are the pros. And then the cons are, it wasn't a passable street by 1953 when the subdivision bylaw came into play, because it was overgrown, as we've heard from two of the citizens here. There's a stone wall that's covering most of the path. If there were a path, over time it's been overgrown, and at best, I don't think it's wide enough to be a street at the juncture between the two homes. So at the best, I think the only argument would be you could have a walkway, but you can't have a subdivision built with just a walkway. And the wetlands on Leonard Street kind of preclude anything from that Leonard Street side. But from what we've heard from the people who have come here and taken their time to come here, which we should respect, I'm thinking that the no's outweigh the...
You don't know that, right? We have to do the vote.
Sure.
Just
No, I
identify
mean, for me, it's the
arguments.
facts.
Okay.
Right.
That's fine. Any other discussion points before voting? Quickly.
I'm just hoping, can we put that the oldest site plan up?
38, the one right there?
Is it 38? Was,
Oh, the site plan?
the
photo?
plan.
46.
Oh, plan
46.
46.
Yeah.
And can we zoom in,
One on the left.
we zoom in on it? Can we get it any closer? Can I go up and, thanks, because I don't have it in my packet. I just want to look at this.
It's on page 146 of the December 17th packet, if people want to look it up.
So, there's a stone wall on either side, correct?
Yeah.
Yep.
Going down that.
It goes across
And then
two-thirds.
what's the next generation? We have one for,
So this is this 1946.
okay, and then what's the next oldest?
I don't know when there's another.
When is the next?
Well, it's the wall we all climbed over, right, if we
What
went
is
to the sidewalk.
is there any one closer to 1953? Is there any other?
There's no other.
Okay, so there is, okay.
Well, the survey plan that's in the set that they submitted.
Right.
Project.
You had it on that one.
Which is essentially
Yeah,
the
yeah,
same.
that's
Essentially
the
the
one
same.
that's the one I
Essentially
want.
the same.
Different.
Essentially the same thing.
All right. Any other discussion? I'll entertain a motion to approve or to, I guess, approve the way in existence?
I would say, make a determination.
Okay, to make a determination.
That Buckland Street-
That Buckland is a way in existence.
Was
of 1953.
Yeah.
Thank you. All right. So,
So I will move in the affirmative that there is evidence to determine that Buckland was a way in existence in 1953.
so motions are a second.
I'll second that.
All right, so motion and second. All right, all those, or any final discussion?
I just had a question on your motion. You said in the affirmative.
Right, I'm making the motion in the affirmative, so we all understand what we're voting. If we vote yes, we agree that it was, the evidence supports that it was a way in existence in 1953, and if we vote no, we disagree with that.
All right. We all clear? All those in favor signify by saying aye.
Aye.
Aye. All those opposed?
No.
Nay. Anybody abstains? Anybody abstain? And I think, I don't think we need to do a count, and I think it sounds like the noes have it, correct?
2 in favor?
I think 2 in favor, right?
You said?
I did, and Deb? Right? And everybody else was a no, so the motion does not pass. All right? All right, thank you very much. Make a motion to close the public hearing?
What?
Or this?
You have to deal with the stormwater.
We need an extension on the,
Well, but you need to get the
Extension, yeah, need an extension of time to the.
Right, so to make a motion to,
So
so 2 things. Go ahead, go ahead.
The petition for roadway approval is still before you, so you should ask Mr. Petrosi if he wants you to go forward with that at a subsequent meeting, or if he wants to withdraw it. And then regarding the stormwater permit, you need to get, Mr. Petrosi needs to agree to extend the deadline for action.
All right. So, Mr. Pedrosi, the roadway extension.
Well, let me ask a question through town council, through the chairman to town council. So it's my understanding under the law that we are, that the lot that is existing on Buckland Street today, we are able to construct roadway and access to that one particular lot. Am I correct?
Yes.
Okay. So, so the action that was taken here tonight only disqualifies the possibility of an A&R endorsement.
Exactly.
So, just so the board understands that we will be proceeding with the construction of Buckland Street, and we will pursue whatever other development options are available on the site as a single lot. Presumably, and if it becomes necessary to file what I would believe to be under the subdivision control law now you're implying by this vote. So if we're not.
Right, as I see it, those would be your 2 options, would be
Right.
to develop it as one lot under 81FF,
Right.
or come back with a definitive subdivision plan.
Right, under a definitive subdivision plan, that plan would be, the board's scope would be limited to the right-of-way, the standards related to that right-of-way as it existed. In other words, compliance with the regulations as they stand today under the subdivision rules and regulations would not be,
No, that's not the case.
well, what did you do with Box Mill across the way? That Box Mill was constructed under the subdivision, as a subdivision, but within the right-of-way of a 30-foot right-of-way. So what I'm trying to understand is what your standard is.
That was also a petition like yours. It wasn't.
Yeah, exactly, but it wasn't an A&R endorsement. In other words, they didn't qualify as a way in existence.
They did.
They did not. Right? I mean, I'm just reading from the town council's prior ruling.
I was not prepared to address this
I just
particular
want to
question.
understand going forward. So we'll extend the
Okay, I guess that,
petition for the construction of the roadway, but, you know, the board will have to make a decision on that. At the next
we'll come back.
meeting.
So we're going to extend it out.
And what's it-
Well, when is your next meeting?
I was going to say,
it's like the 5th, 25th,
Skip the 11th because of town meeting.
February 25th, because we have a special town meeting.
Oh, that's right.
Okay.
So the February 25
The agenda is full.
on the 25th? What's the next one after the 25th? March 11th.
So point of order,
Wait, hold on, I'm just going to
I
lock
think it
down.
affects this scheduling.
Okay?
We were told that if we voted something down, we need to regroup and line up all our ducks and document the reasons for it. So I think that would take, we should do this with this situation, and that should occur before we meet with them again.
Or do we need to do any finding of fact now, as part of this vote?
The question is, do they need to make a motion to not find that it's a way in existence and cite reasons for that? Make findings.
That will be done as in the decision of petition on the roadway. I mean, yeah, because that request was made as part of the petition for approval of the roadway, so that's the written decision will be the decision on petition for roadway.
Well, what is our right to appeal then? The board has made a decision, we don't agree with it, so we're gonna appeal to the land court, so we need a decision that gets recorded that we can have some appeal rights under.
But there's no plan before there's no A&R plan before the board.
Well,
So you've asked for the determination as part of the petition on the roadway. If you go forward with the petition on the roadway, that determination will be part of that decision, and you can appeal that aspect of that decision. Or you can come before the board with an A&R plan.
which we did at the initial stages, and we withdrew it as a courtesy, so the board would make the decision on the entire development, but we would need to have a decision that we could appeal, so we'll file an A&R plan, and you can make your decision at that point, and we'll appeal it to the land court.
You can do that.
Okay. That sound fair to you folks?
Sounds fair. My question then for Lane and Town Council is, what information do we need to have documented, so that we're ready when he, submits the A&R, and if he then, goes back to land court with an appeal, that we make sure that we've got everything covered.
It would be at the time that the A&R plan is before you, at that time, you'll make a decision.
Yep.
You can reference the minutes from this meeting, but that's where you'll make your findings. And in the context of that proceeding,
Understood.
you could briefly revisit, the facts that we've
Understood.
discussed at great length.
Yes. I would keep good notes,
That answers
everybody.
my question, thank
I
you.
would keep good notes. Okay, so in terms of the roadway and the stormwater, those are gonna be withdrawn?
Oh, no.
Present?
No, we're not.
So you're gonna keep them out there, right? You just want to get on the next docket for March 11th.
Hey, could you just, if I may, Mr. Chairman, because of the deadline in the stormwater bylaw, the applicant just needs to go on record.
And that will be extended as well, correct? The deadline for the stormwater piece?
Right, exactly.
That's right.
The applicant just needs to
Agree to that.
confirm that he agrees to extend the deadline.
So what are you asking me to continue?
So the deadline for the stormwater management, I believe, was February 11th?
Okay.
And I guess the question in front of you now is to have that extended out a couple weeks past the March 11th date, so
Okay.
call it March 20th. I don't want to make something up, Kobe, would that work?
Sure.
Do we need to vote on that? Or, I thought we normally voted on the extension.
To continue to.
Yeah. So I'll entertain a motion to continue the public hearing for Buckland and Leonard Street to March 11th
So moved. At 7:30?
at 7:30.
Second.
So there's a
Seconded.
motion and second.
And then also the deadline?
Also, exactly, also to extend the deadline to March 20th. So we kind of lump those both together under the current motion, and that's been seconded. All those in favor?
Aye.
All those opposed, abstain? So carries. See you on March 11th,
Great. When is your next meeting after this?
The 25th,
25th.
February.
February 25th. Because there's a special election meeting the early part of February, so we get pushed.
Thank you.
Thank you very much. All right, so apologies to the good folks who have been waiting diligently. Do I need to kind of reopen that, the public hearing? Or just for 52 Spring Street? So this is an application request for, to move a stone wall. The applicants who live at 52 Spring Street are looking to, well, I'll let them explain, but building a new garage, and they want to move part of the existing stone wall that's on the front of their property. So, sir, please introduce yourself and give us a little backdrop.
All right, will do. My name's Jeff Neal. This is my wife Penelope Neal. We've lived in Hopkinton now for over 20 years, nothing in comparison to some of our respected members that spoke tonight. We've obviously had quite a history here in town. It's kind of fun to listen to them and hear the history. But like I said, we've been here over 20 years. We've lived in our current home at 52 Spring Street for over 17 years. On the home is a Cape-style single-family dwelling with a single-car garage with an attached barn to it. At this time, we're going through the various approval processes in town to be able to build an addition and a garage onto that home. We met with ZBA last week. We received a unanimous decision to go ahead with our project as far as they were concerned with zoning. We're looking to remove that single-car garage from the property along with the barn and looking to add a mudroom and garage attached to the home. This will give us a little more usage of the home, but it will also help us to be able to increase our safety and the safety of those traveling Spring Street, because I think if you see in your packet with the picture, you see it's a single-car driveway that makes it so we have to back out onto Spring Street. Over the past 17 years we've lived in the home, the amount of traffic on Spring Street has greatly increased, but even more concern is the speed of traffic that has been increasing as well. So a new driveway at our proposed location will allow us to pull forward onto Spring Street and pull off of Spring Street in a forward fashion as well. But to do that, we're asking the board tonight if we can open a 15-foot section of the stone wall. Our plan is to take the stones from that section and move them to close up the existing driveway. So in essence, the linear footage of stone wall within reason will stay pretty much the same, just an opening in a different location. And that's kind of it in a nutshell.
Any questions from board members?
More of a, not a question, but it's more of a statement. You guys have a very concise and clear plan, and I like that you respect the scenic road bylaw, and you're planning to reuse the stones and just changing the location of the driveway, and it's very thoughtful and well thought out.
Thank you.
Well planned, I should say.
Thank you.
Thank you.
So, any other, Carol?
I just have a question in terms of what do you anticipate doing with your existing driveway? You're going to take that out? And
That'll be
grass it?
gone. It'll be grass, yes.
Okay, thank you.
Can I clarify, are any trees in the right-of-way going to be removed? Or
Any trees?
any trees?
No, in fact, where you see the opening, it was not the ideal location. We actually, there's a tree there that we've worked to work around that tree, so we'll preserve that tree on that scenic road.
So is the roadway, just for my own clarification, is gonna, the driveway, I should say, kind of gonna loop a little bit, because it's gonna be closer then to the fence where the neighbors are, because there's in front, there's a tree, fire hydrant, and a telephone pole, just to the left.
Yes. If you look on what you're seeing on your screen there, that driveway will go up, and that 24 by 36, 38, that will be the side-facing garage. So that driveway is going to wrap and curve right into that garage, three-car garage. So it stays clear of the fire hydrant, the utility pole, and the tree.
Are you anticipating using any new stones? Or are you just gonna literally just keep the same and?
We're hoping to just keep the character and aesthetics and everything as is, and just move those stones.
No cement?
No. We want to preserve the character as it is now.
Yeah, no, I was thinking the same. Yeah.
And you're familiar with how old stone walls are built, the larger stones on the bottom? And
Yes.
Do you want to help build us?
We'll take any muscle power we can take. Yeah, absolutely.
I was just going to add, I think for the last few stone walls, we've been just asking people to document. You have the photographs of before, but if you could take photographs after, in case there's any question that the plan wasn't followed, we'll have documentation.
We'd be happy to.
Okay.
Yeah, and just to follow up on that, if you could take some close-ups of before as well, at the stones, that'd be great too.
Sure. We'll make that happen.
Yeah, I think this is pretty good. I appreciate, I think, to Mr. Durso's point, you've come forward with a pretty clean plan. I think part of it is safety too, trying to back out there. I drove by it today and you're kind of at a weird bend a little bit.
Yeah.
So I think, from all those factors and keeping the aesthetic look of a historic road is well within. So, any other questions from board members before vote? I'll entertain a motion. Oh, fire chief. Oh, Chief Slayman. Apologize. Come on up.
Thanks for the opportunity. I guess I evaluated the driveway. Considering it's a new access to the property, I would like to have the driveway bylaw access apply. So what I'm seeing is a 15 feet opening in the wall. What we require is a 12-foot driveway width with 2 foot of shoulder on each side. So the 15-foot opening in the wall would be a little too narrow for what we would normally access to get into the driveway. And then the second piece, they just want to analyze out on the apron on Spring Street. Spring Street's pretty wide, I think, in that area, so it should make the swing okay, but they just want to put a template on that gives us a chance to get the first emergency vehicle in off of the roadway of Spring Street if we're servicing the property.
Okay, so that would be a little bit different than I think what's on the plan here. The plan you've got is 15-foot opening?
Yes. Which, can we amend that to 16 feet, and that would
I think that would be the idea in order to...
Yeah, so the minimum width would be 16 feet you want for the clearance of the vehicles. It shouldn't take more than that. It's nice to whoever's doing their work that they could just assess that on the swing it'll work okay. My gut says it will probably work okay without being much bigger, just because the wall's set back some. But generally, somebody determines that will work. I don't go in. I'm happy to show up during construction with vehicles. That's what I've been doing for most of the driveways the last 2 years. If anybody has a question, they do a rough opening. I pull up with the vehicles and we just see whether it works, and then they can kind of stretch it out if it needs it, or not stretch it out if we have enough room to do the swing, just to confirm it.
Okay, and this would be 16 all the way, the entire driveway length, all the way through, correct?
So that's the way the bylaw's written. It needs to be 12 foot of driveway with 2 foot of shoulder. So if it's paved, it would be 12 feet of pavement. If it's not paved, just 16 foot of the pervious, am I saying that right? That right, yeah.
Pervious.
Yeah, surface. So it has to have 16 foot of clearance overall. And I can give a copy of that if you need it.
So does does the 16 foot, so what you're saying, 16 foot in clearance, that means that's including the radius. So at the very opening of the driveway, right on Spring Street, it has to be 16 feet.
So what we provide is a template that they can use. It's a 20 scale template you could lay down on the proper, your builder could probably just lay that down to check the roadway. That's what most of the builders are doing right now. They just lay it down and demonstrate that the swing.
The swing, so it's like a 2 foot.
Depending on the width of the road will determine on the apron how wide it will be. The wall's in a ways, so usually we start the swing and then the wall could have a narrower opening to 16
So you could go
feet
back to the
as the
15
narrowest.
feet.
Yep, we can make that happen.
And the words in the template should get you
Excellent.
through most of it, and I'm happy to meet at any time if you need me to come in and just help out with it.
Sure, absolutely.
Very good, thank you, Chief. And does that work?
That would work, yeah, we can make that, as long as you members are okay with a 16-foot rather than the 15-foot. We can certainly do that.
Ross?
So, Mr. Chair, how does that affect the motion? Then it would be up to 16 feet plus any additional distance that the chief may find that's needed?
Well, I think the opening has to be 16 feet, right? And what the applicant had initially proposed is 15 feet. Sure. So I think the motion would be to vote on a 16-foot wide opening, so removal of the stone for 16 feet in order for the driveway and the access for emergency vehicles.
No, he was actually saying that the stone wall is set back, so technically the stone wall could be 15 feet. But at the very radius, where you have the radius coming in at the very entrance, it would need to be 16 feet. So the roadways, if the stone wall is 2 foot back from Spring Street, just say it's 2 feet, which is typically what they are, that you can have that 16-foot radius go back to 15. I thought that's what you were saying.
The width for the driveway is, the minimum is 16 feet. So the wall, right away I saw, it has to be a minimum opening of 16 feet.
All the way
Most
back.
driveways on the apron, right out by the road, will have to be a little bit wider.
Oh.
It could be 17 or 18. If it's a really narrow road, then it has to be a lot wider. I don't think that's the case here. So, but you'd want to say at a minimum of 16 feet and then meet the turn at the apron, which is what the key is.
And that's going to be further studied. Okay.
So then the condition is that it meets the fire department's safety template and that they'll use the stones to replace the gap.
Correct.
For the previous driveway.
Mr. Chair, I think what you were saying was correct. 16 foot.
I think 16 feet. So are we clear with the motion at hand?
Someone make a motion?
I'll make a motion to approve a 16-foot wide opening in the stone wall with the condition that the opening meet the fire department's template for turning and that the stones that are removed are used to rebuild where they're going to get rid of the previous driveway.
Second.
Right. I have a question. What if the template results in the fact that they need a wider? Do you want them to come back to the board at that time?
It probably makes sense, right? It would be relatively quick and easy, but if it doesn't fall within the parameters as defined in the motion, then I think the applicant would have to come in front of the board with an amendment to that to make it a little bit wider. So let's keep our fingers crossed, but yet know that we have the ability to review it.
I'd actually rather word the amendment in a way that they don't need to come back, just knowing how
That would be
construction
probably easier.
sequencing happens here, and if they're looking at another month delay because the fire truck overlay said they needed 17 feet instead of 16, I'd rather just word it in such a way that it's 16 feet or maybe it's a max, or I'm not sure, something.
Up
But
to 18 feet if required by the fire department.
yeah.
All right, so do you want to,
I wouldn't even put a number to it. I would just say in coordination with the fire department, it has been determined that you need a 16-foot width. With using the template, they need wider than,
it's a long motion.
Do only
I wonder
what
if
is
we can just
necessary.
make
do
that a
only
little
what
bit
is
shorter.
necessary as determined by working with the fire department.
So let me, I mean, on their property, we're gonna work with them to be able to do the driveway that they want to do and replace the stone wall.
Mhm.
So whatever we can make the motion to be as flexible as possible, right?
I would suggest that whatever they need to take out to accommodate the fire department is rebuilt the same distance at the other end.
There we go.
So if they have to take out 20 feet, they build 20 feet with the stone.
Right.
Okay.
So you made the original motion.
I would accept Carol's friendly amendment.
All right. So there's a friendly amendment to that motion. Can we do that, Elaine, or how do you want to do
The
it?
opening can be as wide as necessary to meet the fire department's template, and that the stones are used to rebuild an equal section on the other end.
Yes.
Does that work for everybody?
So,
I don't mind that, only, I don't foresee it as a problem, but if the demographics of that picture you see with the driveway, if we were to add further stones, it will change the whole front landscaping of our current property. So we will, if we had to go 20 feet, that might now start cutting into the curve of Spring Street and impact it in a way. What's that?
So,
figure it out.
so
But
just to
we'll work with
amend that statement that Carol said, that use the 20 feet to fill in, use whatever amount is necessary to fill in the prior driveway.
We can, perfect, that we can do.
Okay.
So point of
So is
order,
that-
the friendly amendment was accepted, and does it need to be seconded?
I don't know, Elaine, does that,
It's been seconded.
I think we're all set.
Did someone second the motion?
I don't think so.
I will second the friendly amendment. That's been accepted.
So there's a motion accepted, there's been a friendly amendment that's been accepted as well. Any other discussion from board members? All those in favor signify by saying aye.
Aye.
All those opposed? All those abstain?
One abstain, I'm just in the general neighborhood. Just one abstain from the vote.
Okay, one abstention. All other members voted in the affirmative.
Thank you.
Why were you abstaining? I'm sorry.
I'm in the general neighborhood, live near there. I just didn't.
All right.
Thank you.
Thank
So,
you.
Thank you very much. Make a motion to close the public hearing.
So moved.
Second. All those in favor? Aye. All those opposed? Thank you very much. Good luck.
Thank you.
All right, we are woefully behind. That is on me, so I apologize. Next on the docket, traffic signal. Mr. McDowell, this is for discussion around, this is not a public hearing, so this is for a proposed traffic signal on Legacy Farms north and south intersection with 135. Mr. McDowell, brief overview. The floor is yours, sir.
Good evening. I'll save you a conversation with Beta. VHB, who did the traffic analysis for us, does not believe the light is necessary at this time. Beta does think it does. So rather than debating it, we're just going to do it. And we have a meeting with Thursday with VHB, who we're going to put under contract to design the lights. And once they've done that, we'll submit it to the planning board, who will then give it to Beta to review it and approve it. And once that's reviewed and approved, we'll put it out to our traffic light person, who will then have to order the parts. We'll install the lights.
Wow, it's a great update.
I figured that would make it easy.
You almost got me back on track, Roy. Thank you. Any other questions for Mr. Terry? I was going to open up to the public, but
I have a suggestion. Thomas Terry from Maple Street again.
Have a seat. How are you?
Nice to see you again.
Nice to see you. So you remember all the way back to 1954. I'm very impressed.
1939. When Joe DiMaggio came into the major leagues.
wow, that's good.
When this traffic light is built, because of all the Curtis Road there and the two curb cuts from Western Nurseries, and both, there's a grade there, and there's not only a grade, but there's a corner. I was hoping that you might put warning signal lights, like 500 feet on each side of the light.
That's typically
the other way.
that's typically done with signs. Now,
Should be flashing lights.
I'm not the traffic engineer, so again, I'm meeting with VHB specializes in this type of work. So when we meet with VHB, they'll tell me what the AASHTO and Mass DOT requirements are. And then whatever they are, they'll design it per whatever that is. We'll submit it to the planning board and to Beta. Beta can critique it. And if everyone's in concurrence, we'll build it that way. If for whatever reason there's some critique that comes from Beta that we then go back to VHB, we'll get everybody on the same page. The most important thing is it has to meet DOT standards. Not my standards, frankly, not the planning board standards. It's really Mass DOT.
I was just wondering if you might suggest that they do that with flashing lights, because I'm picturing a snowy night in January and some child is trying to cross the road down there, and it's a very dangerous. You can't see 100 yards either way before you come to the light. And
Well,
it's a
actually-
45-mile-an-hour zone, I believe, isn't it?
Actually, you can see more than 100 yards. The whole reason for dropping East Main Street, we dropped it I think it's 4+ feet, is to extend that vision line. So you actually do see more than 100 yards.
I beg to differ, but I'm not going to belittle that point. Thank you very much.
Okay, thank you. We'll happily take a look at it.
Can I ask just a question, like
Sure.
in procedure? So who determines what's when they're flashing and when they're, straight out streetlights?
Well, again, you don't have to have them flashing. I'd be surprised if you had them
I
flashing.
mean, like during non-business hours, will they flash yellow so that people can proceed with caution versus stop?
Again, I think that's going to be purely up to the town and the designers. When they put this box in which controls the lights, the DPW can go over and change that anytime they want. So if you want them flashing, they'll be flashing. If you want them to be, typically they run in a cycle. The majority of the time, Route 135 will be the dominant. So pick a time. If every 10 minutes, one is on and 2 minutes for the other, because it all goes by traffic flow, because we already have the traffic studies. So they know.
Yeah, they were very good, thank you.
So they know the traffic in each road. The other thing they also know is they know all the right and left turns. So I think all that data will go into the design of the lights. But the good news is you can change those whenever you want.
When the traffic volume changes.
Yeah, that's great.
Is there any thought to, in the middle of the night, to having the lights, instead of being red, green, yellow, just to be yellow on 135 and then flashing
Absolutely.
red?
Yeah, that's what we were taught, that what I was trying to allude to.
Okay.
It's
Yeah,
all
but-
programmable.
Yeah, I would think that.
Yeah.
'cause
I mean,
there's not
frankly,
much
that would make
traffic.
sense.
Yeah.
Okay. That's,
I mean, how many times have we all stopped at, 1 o'clock in the morning, we're at a red light, there's zero traffic, and you're waiting for the light to change?
Yeah.
That's very good.
It's my favorite.
Anything, other questions for Mr. McDowell? Very good, sir. Thank you very much.
Do you mind if I sit here and talk about the next item as well?
Absolutely.
Which is
The proposed zoning bylaw amendment?
Are you on the ZAC stuff?
well, the Oz...
Oh, the Osmond.
The one I'm most interested in, and Mr. Gately is here also. Ben, would you mind coming up? So, we had this conversation with Elaine a while ago, and maybe some of you have noticed, but this has been a big deal in Framingham. There's a number of age-restricted projects going on right now in Framingham, which was the same concept as Hopkinton, where 10% of the units were going to be affordable. It was pretty much set up the way Framingham was, where, Hopkinton, one person over 55, no children living there under age 18. DHCD, which is the one who approves your units going on the list of reaching 10%, is recently denied towns acceptance of those units because they're saying now it discriminates against children. So what Framingham is doing is they've made changes very similar to this, excluding the language. But see, this is only one thing. I assume this goes to town meeting, but you're going to get another whole document, which is the master plan special permit, which actually goes in quite a more detail than this does. And having this amended is fine, you need to do it, because this goes beyond our project. This is for any future project. But more specifically, the concern is with our project, because as Vin is now selling units, the way the decision is written, it needs to be one affordable unit for every 9 units of market rate housing. So the concern I have is once he's sold the 9th unit, what does he do to get to the 11th unit? So the question becomes, are you going to change the language? I don't think you want to change the language like this. You can if you like, but if you do, I don't mean this document, but I mean the master plan special permit, because if you do that, basically de facto you're going to allow children into the development. So if you make that decision, it's in conflict with the other document. The other thing you might consider doing, which is what Framingham is doing, they're eliminating the requirement to have the age-restricted affordable in the age-restricted development, but they're having the developer pay a fee to a fund in town towards affordable housing. I don't think they've finalized the number yet, but I think it's going to be around $150,000 a unit that gets paid to this fund. Now, in this instance, if it were $150,000, let's see, times 18, that's $1.5 million. It's probably $2.4 million, something like that. So it's a lot of money. So I guess one of the questions I have is this document, but the question beyond that is, what are your thoughts on the master plan special permit?
Good question. I was going to, Mary,
Yes.
as chairman of zoning advisory, I was
Yes.
actually going to turn some of this over to you to be able to kind of talk to some of the rationale behind, and some of the decisioning that the group had talked about on this. But I'll have, see if you can kind of maybe address Mr. Dowell's question, and then we'll step back and maybe provide a little bit more context in terms of where this bubbled up from and what some of the board members thought. And things
So
like that.
this first motion, it was brought to us by Elaine, and through discussions and also explained that, obviously, this has to go through state review, is that right, for the affordable housing?
The affordable housing.
Yeah.
That's described.
So we need to change something to this effect.
Regardless, something needs to be changed one way or
Something
the
needs
other.
to be changed. So that is the rationale behind this, and then essentially we just discussed the wording of it in ZAC. We didn't specifically, address what you just brought up of having whether or not this is a developer could pay a fee to the fund. But from what I understand, that's, on a case-by-case basis, and this, we're looking at the overall.
This, I think, covers you. I think this covers you, say, because you've taken out the language relative to children, so it's sort of quiet on the issue.
You're referring to saying at least one resident of every dwelling unit be 55 or older?
Yes, you've crossed off no children under the age of 18. So you've now taken the discriminatory language out. And I don't think there's an issue at all with being over 55. That's what the whole concept is about. So I think this document, I think, I'm not the lawyer in the room, but I think it's fine for the purposes of town meeting. My question is, where do we go beyond that with current projects?
So specifically for this language, do you want to address any aspect of that?
So if this passes town meeting, in order to make it fully effective, the board would also have to amend the master plan special permit to take the language out of there too, and the selectmen would have to amend the host community agreement to take it out of there. So those are just votes of those boards. That could be accomplished if the change.
But it has to go through town meeting first?
It has to go through town meeting.
Okay. And in terms of the bylaws themselves, does this open us up to anything that, we should be concerned about, to have this in the bylaw, this wording change in the bylaw?
Well, if you're concerned.
Do you see any other alternative, I should say?
Well, the other alternative is to remove the requirement for affordable units. So that's the other requirement.
Okay.
I mean, so one of those has to change in order for them to be able to comply with the zoning, because right now no matter what they do, they can't comply with the zoning.
Okay.
Can I add?
Okay. Does that, hopefully that explains relatively.
It does. I mean, I think there's I think we have to look at it in the context of, this is a multiple step process in order for us to be covered, also as it applies to you guys' project as well, right?
Yes.
Amy?
So I understand something has to have changed, but I'm not real happy with any of our choices that we have here. So it looks like one option is to change the zoning bylaw to remove the requirement for affordable units, and then we would be down 18 affordable units in town. And that would bring us pretty close to our 10%, that we might go under 10%.
It's at the next census, we don't know.
Okay. Or we could change the bylaw to remove the objectional language, which I think will bring us some school children, although not as many as in a neighborhood that, because somebody who's 55 can easily have a teenager at home, or
Just saying, it's possible.
be a grandparent.
I think the intent
There won't
was,
be as many children as a
actually, if you look at
development with no restrictions.
I'm sorry, if you look at the master plan special permit, the language in there does not disallow you to have someone, even a child, staying at your home, because they just frankly can't live there. In other words, if a child comes for the summer, they're there with their grandparents, or you have a child who just graduated from high school, and they want to live with their parents for a period of time, could be 3-6 months, pick a timeline. The concept of not having children living there permanently is frankly to avoid the school system. That was the whole concept.
Right, no, I know. So I really hate to get rid of the
Affordable.
no child under 18, but I understand that we have to make some change. Is our third option that we could put money into affordable housing funds so that maybe 18 units could be built elsewhere?
Well,
You would also have to assume that the town would build 18 units.
Would have time.
And I don't know.
Time and land
if
to
the town
build.
has the immediate capacity to do that.
but actually, what we've done in other communities, I'm just going to pick a number, call it $150,000. If you took $150,000 and you did appropriate leverage, which contractors, developers would do, say 25% down, you could physically build $500,000 to $600,000 units. Now, you're not going to spend that much money on affordable housing, but if you spent, say, $350,000, you could easily build 18 units or probably 22 units for the monies you'd receive from the 150,000 times 18. So it's very doable. Matter of fact, there are companies out there that specialize in doing that type of thing.
It would also have to be land.
Right, that we own, yeah. Okay.
Excuse me, could I make a comment? Vin Gately from Heritage Properties, and I'm the developer at the trails. And of course, at the time I purchased the property from Roy, we bought it understanding what was already in place and this language that prohibited 18-year-olds from living in these 55 and old housing units. There is a bigger issue here, which is that from a marketing standpoint, we're now, I don't know if you've been by the trails recently, but we have for units in construction, and we're about ready to start another 6 to 8 units in the next 45 days for people who have signed purchase and sale agreements. Our master deed was set up by our attorneys to basically mirror the language that was in the town meeting vote, which we know would exclude people under 18 from living there, not visiting, but living there. I get to meet in fact, I get to meet every buyer before they actually sign their purchase and sale agreement. And I can tell you that one of the reasons that people move to adult communities like this is because, they're at a point in their life where, just in general, most of them have had children, they're maybe adults, maybe they're in college, but they really like the idea that there's not going to be people 18 and under living there. That's one of the big reasons we get that question all the time. We point them to the language that's in the master deed. Of course, the master deed that they have right now is a draft master deed that we don't record until we get close to the first person who we're conveying the unit to. But I can tell you right now that if that language changes in the master deed and now allows people 18 and over, that's a significant issue for the marketing and basically the success of this community. So I just throw that out there as you're considering how to handle this.
Right, so that's a fair point.
Through the chair, I just have one question though. Is it possible in the language in your deed to have something different than what the town has? Is that still considered prejudicial to?
The state will review the master deed.
Okay.
So
I don't want to cloud this vote tonight. This is a separate issue. I think this looks pretty good, actually. Elaine, if you had a chance to run this by DHCD?
I spoke to them on the phone, and they will accept that language.
Oh, they will? Okay. So this is vanilla, plain simple. So this part's easy. I guess what I'm asking you to do is, offline, probably a further consideration, maybe we should come up with some ideas to present to you as options and give it some thought, because you're right, it's not just planning board, it's selectmen.
Yeah, I know.
It's
multiple touch points.
Multiple.
So could we vote to put this on the warrant and work on the language later? Maybe we could learn more about it.
Yeah.
And there will be a public hearing as well.
Right.
For
So hold on, this is just the first step, right, in the process, right? We'll discuss this, we can actually put it on the warrant, we can massage some of the language here if we get some additional feedback. There'll be a public hearing on this, and then we'll take it to town meeting, right? So that way, when we go to town meeting, we can say, hey, we've vetted this, we've kind of,
But this is town meeting in February, correct?
No, this is May.
Until May.
This is the May, this is the big one. It's a 3-day affair, love affair.
No, we're just concerned about sales, given the fact that this is an open issue. So I think what we need to do, if we could, is parallel process between now and town meeting on the master plan special permit. Maybe even if we could see if you can agree to the language in that, so once this is finally passed to town meeting, you could immediately vote the other component.
Would you like to preserve the option of eliminating the affordable housing as well by having them both go to a public hearing and see what kind of feedback you receive?
I would probably make sense.
I think that would be a good idea.
I think it'd be helpful if we could come with some, Framingham spent a lot of time in this, so I think maybe if we could come back to you, we can look at 3 or 4 other communities who are dealing with this, come back with some of the better ideas that other people are looking at, maybe give you a menu of ideas to consider.
Yeah, I think it's only going to be helpful, right? Kind of help frame in the issue and what some best practices, using that term loosely, but what are other communities doing and what makes sense. One question from the audience. Katie.
I thought this was a discussion that everybody participated in. What do you mean a question from the audience?
Or a comment from the audience. A comment from the audience, please come forward.
I wanted to participate in the discussion.
I'm asking you,
Okay.
I'm giving you time for a comment.
Sit here.
I would. Thank you. So this
what we're discussing here is something that, language change to the OSMUD. And when it was put on the agenda, it was put there initially without any change bars or anything, and I asked the question, well, you know, is this just an open discussion for any changes to the OSMUD? And eventually it came back that there were 3 proposed changes. So my comment is that I also have a proposed, a small proposed change, and would like the opportunity for that to be considered as well. So I just was kind of taken aback that it was kind of brought in without initially saying what the changes were. But I would like, I have a small language change that I would like to be considered as well. So,
Yeah, I think we're open to that. I mean, typically this came from the zoning advisory committee.
Right, and I've been to a couple of their meetings. I wasn't
Okay.
able to go to the last one, but I will certainly go to the next one. But I did have a small thing that I wanted to
Throw it out there.
consider. Okay. So what I wanted to discuss and consider was the setback, the setback requirement for the OSMUD lots that abut the non-OSMUD lots. So there's currently a setback there for that condition, and I believe it's 50 feet, but I could be mistaken. I don't know if anybody can confirm that or not. If it is, it's, regardless, my language change is not to the size of the setback, but rather to add a condition. One of the other setbacks currently has conditions attached to it with regard to the development of the setback. It has language saying something like the setback shall not be developed, but it shall be landscaped. So there's a condition attached to the setback. So what I was interested in having considered is for the setback that abuts the non-OSMUD land, that setback be undisturbed. And I was meaning, and there could be additional language attached to it. Obviously, my continuing concern is the part of the OSMUD that abuts Wilson Street for which there is no drainage. So the language change that I'm asking to be considered is that that setback be undisturbed for the purpose of preserving the or not negatively impacting the current drainage situation, which we know is marginal. So I think the setback, for this particular setback of the non-abutting residential properties, I think there's a presumption that the abutting street is engineered with drainage and all, and of course in this case it is not. So I think that where there's conditional language attached to the abutment of the OSMUD to commercial land, I think it's fair to consider a condition for the abutment of the OSMUD to non-OSMUD residential land. So that's basically it's to consider having, and right now we went into great discussion about that, preserving that area undisturbed in front of Kruger Road. But I think it would be worth adding a couple of words here to say that setback shall be undisturbed for that particular condition, that it abuts a street has substandard drainage or whatever. So that's the language, and would I submit that in words, or, I mean, to the next?
Yeah, so what I'm thinking is, I'm just looking at this quickly, where you would put it would be somewhere between page 9 and page 10, possibly at the end of A. So
Yeah, there's a table that
yeah, just
says all the
with the
setbacks.
asterisks. You add an asterisk
Right.
down there.
And is it the 50-foot? Is that the one that applies?
So it's item B that applies to lots within the Osmond that abuts land outside the Osmond district.
Okay.
And there's a table. And the minimum side yard width is 25 feet. The
This,
rear yard,
this would be the setback from the street.
setback from the street is 50 feet.
It was a little confusing because there's also a 20-foot item, but I couldn't tell.
That's the rear yard.
So on that 50-foot one is the one you're talking about? That's the
That's
one?
what I think I'm talking about. but
Okay.
it's-
Oh, okay, so it's B.
And also where it's measured from. It was a continuing point of confusion where it's measured from. Is it measured from the boundary of the Osmond or from the center of the street? So it would be, I think it would be good to make it clear.
When it references the street line, that's a term that's defined in the bylaw, and it's the property line adjacent to the street. That's where it's measured from. But I just wanted to note, too, that it doesn't apply retroactively to anything. Everything that has been approved and permitted is grandfathered, so it would only be applying to anything new that comes forward in the future.
It sounded like there was going to be changes based on, like you're going to have to change the host community agreement because it conflicted with
State law.
with
Yeah, the setbacks
State
aren't
law.
addressed any place other than the zoning. This is the only place where setbacks are.
Is there? All right. So I think we've got it, but I think, Roy, you had a comment as well on this? Okay, yep. So,
So what is the way forward? Just to propose, submit the red lines to the next meeting, or?
So this has to go on the warrant now.
Right. Warrant closes
Yeah,
on
for this year.
yeah, so it's going to happen like now, if we want to add.
Right, but there's
some
going to be
language.
a public hearing, and are there language changes at that time?
We could do a placeholder.
Yeah, I was going to say, right, so,
We'll let Mary.
Yeah, okay, okay.
I was gonna
So yes, all of the warrants that are gonna go forward to town meeting this year have to start right here and now, because we need to get it onto the warrant as of February 4th.
And this is our last meeting before that.
And then planning board will hold a public hearing, likely we were talking about March.
It's February 25th.
Oh, that's gonna be on February 25th, okay. So the public hearing for all of the changes that we're proposing,
But only the ones that,
Consideration.
only the ones that we receive by the time we need to do the hearing notice, which is, I think, the end of this week.
right, end of this week.
So if any come in after that, we'll have to have a second hearing.
But could
From
I
citizens'
submit it to you now?
Yes,
And it could it be on there, or?
it could be.
So we would have
We
to
can have
vote, right? Or could it be part of,
You could,
part of
do
this
it through the
change?
planning board, or you could submit a citizen's petition, or both,
When does a citizen's petition have to get in?
by February 5th. So you have a little more time.
So I could just send it to you both, and then it'll go in as what? As a proposed, or it'll be marked up, or?
If we do it through the planning board, we'll have the chance to work on the language some more and get comments from the public on February 25th. If you do it as a citizen's petition, doesn't it just go straight in?
It just goes right to the selectmen,
You have to get 10 signatures.
10 signatures.
No, I would want to do it through the planning board, so I would just email you the language, and then would it be part of?
So we would have to vote a placeholder tonight.
Yeah, we have to vote it tonight. So, if we can come up with some proposed wording.
Because are you saying that when you have the public hearing, you don't make any wording changes, you just go yay or nay? Or?
No, we could make wording changes
You
then.
can make wording
But we need to
changes.
start with something.
You have to have at least something.
Right, so when we advertise the hearing, we have to give people an idea of what will be discussed. So if it's something that you wanted to go ahead with, we could talk about what that wording might say, and we could draft something that people could have before the hearing.
Yeah, I would like it to be a part of the markup that you have, to the extent that you can do that, and I'd be willing to submit language, tomorrow or anytime, but, Yeah, all right. Thank you.
Okay. All right, so, very good. Roy, you had a comment, or?
Yes, as Elaine had mentioned, things that have already gone through site plan review and have been permitted are grandfathered, and I'm not quite sure the purpose in this, because everything on the north side has been permitted. The age restricted, everything. So it really would have no bearing on anything on the north side, and the south side is fully complete, so I'm not quite sure what relevance it has.
Well, I think it would apply to the unconstructed commercial areas and also the town's parcels that are within the Osmond as well.
Do you really want to restrict the town in that way?
That's something to be discussed. Undisturbed is undisturbed. Something to talk about at the hearing.
Something to talk about at the hearing.
I would request that if language comes into you, if we could please see it before you vote on it, because it could have a unintended consequence or a negative impact that no one is thinking about.
The hearing is a great place for...
Say again?
I think a public hearing is a great place to...
No, I know, but we'd like to get it before that if we could.
It'll be advertised before the public hearing.
And that hearing's going to be on the 25th?
The 25th, and so we can create some language this week.
Well, I'm not creating anything. I'm fine with the way it is.
Yeah.
I
So,
just want to make sure that we don't create some dangerous situation where someone just came up with some language they decided to throw in the ring here, and it has a negative impact on the completion of the south side.
I think that's a fair point to consider, given the fact that everything on the south side's done. The things on the north side are complete. Elaine brings up a point that, there's some public or land owned by the town that abuts there. So I think having those additional facts allows us to be considerate in terms of the decision.
We'll also have a potential negative impact on any future development at Western Nurseries, because Western Nurseries parcel is in the Osmond, in the future development of anything there, so I think it's important to get the Messets involved to make sure it doesn't adversely impact them.
And because, the real benefit, and I don't know if I want to belabor this, but, what's the real purpose of having this language included? That it's just not disturbed land versus...
No, so that we don't further negatively impact the idea is to restrict it to abutting streets that have substandard drainage, right? Because the disturbing of the land, we've demonstrated that causes drainage problems. We want to avoid further drainage problems by when you abut a substandard street, that you don't disturb just the setback. That setback you can't build in anyway. And in the case of the Wilson Street, it's at the rear. It's not the front door. It's the back. They're backing up. So you could restrict the language, but the idea that you can't just ask for goodies. I'm not asking for goodies. The idea is to mitigate the drainage issue. And if, without language in there for it to be undisturbed, we have an example of, what happened. There was no language to say that the setback should be undisturbed, so it was clear cut, right? So, and that created a situation that we're still dealing with. It's still unresolved. So I wouldn't want to make it a blanket language to cover the whole Osmond. It would have to be tailored to specific circumstances.
That's fair, and I understand that. And I know, Mary, you might have a comment, and I'll allow it here in a second, but I think this is all fair for discussion. I think I have some thoughts on it as well, that there's some benefit to be able to do some work, landscaping work around there that would actually help mitigate some of those drainage issues, but I think that's something to be considered. Deb, do you have a comment? And then I'll open it up for Mr. Catino.
Yes, I would suggest that perhaps Osmond is not the section of the zoning bylaws where this would be most applicable. So if Mrs. Towner is suggesting this as, how to perhaps avoid some issues that have been seen in this particular development, but for future developments throughout the town, then I think the undisturbed aspect of it, might apply to more broadly within the zoning bylaws, so.
It's fair, it's a fair point. Mr. Catino, please come forward and state your name and address.
Just a quick comment. John Catino, 1 David Joseph Road. Yeah, I just wanted to make a comment that the town land is on East Main Street, and there was a lot of work going through Concom to set up for a bridge access going in there with all of the water mitigation and everything else. So I just want to make sure and it's all within that 50-foot range. And I just want to make sure that that any of this language wouldn't mess up compliance with Concom because it all is for water mitigation, to make sure that it stays flowing where it's supposed to be. And if we do something too broad right there, then that makes that land completely unusable.
Related to that, I don't think a lot of East Main Street has drainage in it, that section being probably one of those. So I don't know what's considered substandard, but that might be substandard.
So I'm just asking to if it could be as specific as possible, and to Ms. Marlowe's point, to look at it on a broader scale and include the water mitigation part of it, as opposed to just saying leave it undisturbed, because sometimes you have to disturb it in order to make it right. Thank you.
Fair point. Thank you, John. Right, any other comments? Deb, I'm going to actually turn this over to you.
Okay.
Oh, Mary, I was going to leave Deb. I'm sorry, Mary.
That's right.
To also talk about any other changes proposed by Zach.
There's one other change that went through Zach that is in the packet, and it's just, one page down from the 55 years or older. No on-site apartment, this relates to assisted living.
On-site.
Fairview Estates.
And on-site personnel. So what has been requested through Elaine by, I'm not sure which facility it applies to, but we have several, on.
Fairview Estates at Legacy.
Fairview Estates. And so, but, this would apply to places like on Golden Pond and things like that, so.
Look, they're in a different district, so they don't have a cap on dwelling units, so they are not restricted.
This is all the Osmond, right?
So, Fairview.
Yeah.
But it has to do with people who live on the site to manage that facility. And so, right now, there are apartments there that do not have full kitchens. And so they've been having a lot of problem keeping people, so, in that job, because they don't have a suitable living environment for them. And so what they're asking for is essentially I can't think of the word.
Two dwelling units.
Yes.
Complete
So,
dwelling
yeah,
units with
so they're
kitchens.
asking for the ability to build out those apartments properly, but have an apartment on site, but have it not count toward their maximum number of dwelling units, because the dwelling unit's applying to only the residents of the assisted living facility. So that is the purpose of this added paragraph. We did discuss having it limited to no more than 2 apartments, but there's also the issue of why didn't they include it right away when they built it and use one of their total allowed dwelling units for this this resident manager, so. Okay.
All right. Any comments?
Were you asking?
Yeah, go ahead.
Fern, you might remember too, there was a limit to the units, and it was kind of a concession to have to managerial units where they weren't necessarily full apartments. And that's what they asked for and that's what they got. If they wanted 2 more units, they would have had 2 less two less patients or customers.
Right.
So now they're coming back after the fact. And I always have a problem when people come back after the fact. So I'd be against this change because it's what we approved at the time and it's still valid for the time it was approved. But you can disagree, sure.
No, that's fine. That's why I came to support Mary on all of these things, just in case. No, it's not for 2 units in Fairview, Fairlawn,
Fairview.
It was actually 2 housing units within the entire Osmond. And since there are different sections and everything else, so that's what it was. It wasn't 2 units, because none of the assisted living units have any kitchens or anything anyway. This would only be 2 kitchens for the people that live there, the manager and the assistant manager.
But it would be at the Fairview facility.
At the facility.
What John's saying is that, so the resident apartments don't count as dwelling units.
They never counted
They
as
never
dwelling
count,
units.
so that's a commercial use, so they don't count as dwelling units because they're not individual dwelling units?
And what happened was they would have had to eliminate 2 units from another section that was already sold, so there weren't 2 units available to make Fairview
That's what I'm saying.
work.
Except Fairview bought that, they're not the developer, so they didn't have the.
They didn't have the right to do it. So now they're just asking, in order to make it a viable business and be able to have continuity of care, that we allow them to have kitchens for the management. And so, it really doesn't count as living. There's no kids in schools and any of that kind of stuff.
Well, there may be families that would live there if there were kitchen unit. If I may through the chair, also, it's not our responsibility for a business to how can they better treat their employees if they want them to stay? They can pay, there's other ways they can get them to stay. They can pay them better, whatever. It's not our concern.
Well, they have access to the kitchen in the facility too, right? There is a general kitchen.
I think at this point, we're just looking to see if we want to put it on the warrant.
Right,
As a placeholder.
because we're still gonna have the public,
Discussing the
yeah,
merits of it.
we're gonna
can
have the
discuss it
public
further.
hearing on it.
Right.
So it's just.
I'm just so dead fast against it, I don't think it should even be on the warrant.
That's
my
one
point.
opinion. That's
My
one
point,
opinion.
right.
That's all.
Yeah, so I just wanted to come help Gary
Okay,
explain these
and
things.
I just want to clarify one point, is that, are they talking about having units for these people to live in that are not in Fairview itself?
No, these are
They are still
it's
talking about
it's for the
Fairview.
manager and the assistant manager.
Yeah, so it would be at the Fairview facility.
At Fairview,
Okay.
yeah, right. So right now they have basically 2 dorm rooms
Yeah.
for these people to live in. And, because they don't eat with the residents, they don't do any of that kind of stuff. And, so basically they just have to take food in and all that stuff all the time, and that's why it just hasn't worked out for them. And so they were just asking for relief in order to, make the, business a, more,
Right. That's fair.
I do have a question for Elaine, just with regards to the whole Osmond. If we do the first thing that we were talking about, where we're saying that, to not discriminate, you can have people under 18 so long as one person's over 55, and we're putting in potentially these 2 dwelling units that could possibly have families. Does the school children count for the Osmond, count for all of the Osmond?
Yes.
So they would be counted in the,
They
okay.
would be.
Overall cap
All right,
as well.
thank you.
So I think here for us, what's in front of us is do we want to add these 2 amendments brought forth by the zoning advisory committee, move forward to put them on the warrant?
And did we say we might put 2 versions
2
of
for
the
the
other
first one, right?
2, right,
So we have 2 different versions of the first one?
Right, 2 possible options.
Yeah.
right.
Okay.
And there's another one that I distributed this evening too, regarding the recreation parcel.
Oh, yeah. And where did this come from?
So town council has drafted this. And this would, This would clarify or make sure that within the restricted land, one could have cultural and educational uses on a piece of property. And this specifically is related to the town's parcel.
Is this for the Marathon Museum?
Yeah.
Okay.
So it's not in the Osmond?
It is in the Osmond.
It is?
It is in the Osmond, and that parcel counts as part of the overall restricted land for
Yeah.
the development, and it's already under covenant. So it's already covenant to restricted land. But right now, if a museum or something like that was constructed there, it might have to remove that from the restricted land. The developer then would be in non-compliance based on some action that the town would be taking. So this amendment would allow that restricted land to still count if such a use goes in there.
And I think they were always banking on this, weren't they?
Yes.
Yeah.
What was that, Frank?
Depends when you say always.
Well, I think they were banking on that it would be.
Beginning, this parcel was part of restricted land, and at the time, the town didn't know that it might
Right.
have these other options available to it.
Question through the chair to Elaine. Hadn't we already made a motion like this last year, an article that was passed?
So the use is allowed already, but it's not clear that it can stay restricted land under that use.
So this clarifies
This
that.
would allow that to remain restricted
Restricted.
land if
Thank
that
you.
use goes forward.
Got it. So there's another one added to, right? So a total of 3, the first one has 2 options to it. So there's 3 proposals that are in front of us.
And a space holder if you wanted to contemplate.
And a space holder for
So that
contemplation.
would be 4, right?
Yes. So,
And we have to add the street acceptances too, right? Do a placeholder for street acceptances?
Street acceptance, also with Ms. Towner's.
Yes, we
that was
talked
the
about it.
Yeah.
So street accept, right. So, 4, 5, is that total? Yeah, 5, right, 1, 2, 3.
5 little placeholders.
5 placeholders. 5 placeholders. Any discussion from board members?
Yes, please. Can we enumerate which the 5? One is Osmond.
So one is, got 2 options for the Osmond change and that for the over 55.
Correct.
One would be to eliminate the affordable housing, and one would be to change the language.
Or change language.
Right.
Yep, right. And the second one is the continuing care
Kitchens.
apartments.
Right? The third one is the parcel, the museum's
Cultural.
recreational.
Cultural Museum.
Yep.
Well, the third one would be Ms. Towner's.
4th.
Yeah,
Fourth.
Fourth would be Ms. Towner's.
And then 5th is the street
Well, depending
acceptance.
on where it was placed in the.
Fifth is what?
Street acceptance.
Now we're on the same
Oh,
page.
that, oh, okay, got it. Okay.
Yeah, if we separate out the first one in 2 different, it's 6 total. Yes.
Okay.
And the street acceptance would be for Hunter's Ridge and Penny Meadow.
Yes. Question?
Okay.
So I'm just curious to get people's thoughts. I'm not, I mean, going back to Ms. Towner's suggestion, I don't know whether that's right or wrong, but it feels somewhat last minute to me. I mean, we have a public input process through zoning advisory committee. You know, I'm not totally comfortable moving forward with it, just because I feel like we have a process, that process has been followed by everything else. There were a lot of other comments and suggestions that came up through the ZAC process, and I kind of feel like we're giving this one special treatment when there were a lot of other ideas that have been discussed and maybe didn't move forward.
It's a very
I
fair
don't know,
point.
I don't know how other people think about it, but.
It's a very fair point. Any other comments, thoughts?
I actually agree with Gary.
I do not disagree. Well, I agree, right? There's a process in place, and that's the better way to do it.
So then,
So why don't we vote on them individually then, if that's the case? We can go through and that way we're not lumping them all in, but we're doing the due diligence. All right, so I will entertain a motion for the first one, right? We'll do the Osmond one? The first one on the docket? Frank, I don't know if I'm looking down.
So,
The over 55.
They were 55,
right,
right?
so I'll move the over 55 option for the language change to be placed on the warrant.
Second,
There's a motion and a second. Any discussion?
Yes. And I'm probably gonna say this every time, so, in the original town meeting where the over 55 was approved by one vote, it was brought up, how are you gonna limit people to be under the age of 18? And someone forecast, that it's gonna be a problem. Here we are in 2019, it's a problem. It's not, I don't see it as our problem, I see it as Roy's problem and the owner of the property's problem, and I would like to see them, they are suggesting changes, I just need to look at it a little bit more, see what they're suggesting, but we have to look at it for what's best for the town, and I do agree with Muriel's motion that, I don't want to take away affordable housing, I think that a change in the language would be helpful, I just don't know what that change would be, so if we have it reserved for, approved for a placeholder, then I'm okay with that.
Right, I think this is for a placeholder in the public hearing on
Not as
February
written.
25th.
Yep.
We'll work to address that. All right, any other discussion? All right, we're going to vote on it. All those in favor signify by saying aye. Aye. All those opposed, abstain? So passes. Number 2, what is number 2?
It would be the,
Continuing
it would be the,
clarifications.
no, number 2 is the over 55.
Okay, right.
And eliminating the affordable housing option.
And I would make that motion just so that we can discuss it further, because I'm not really clear what's the best option.
Second that.
All right, so there's a motion and a second discussion.
I'm going to be completely against any less affordable housing, even if there's $150,000 per unit and blah, blah, blah. I just think that there's a plan that's in place, and then we have to find, working with the developer, find a way to make it work with the legal constrictions that they exist. They got involved, they're big boys, they understand the law, they have their lawyers, they could figure out these things too, and the state's telling us, giving us feedback that there's a conflict. So, we can work with them, but I don't think we can solve it for them.
Can I just make a comment?
Comment.
We're not, in my opinion, we're just putting it on the warrant so that we can have.
We're just putting,
It's just,
so we can have the public hearing.
right. The public hearings of the venue and forum, that should be aired from.
But for the sake of time, I think some things that, I think I'd like to discuss, do a better job of eliminating some things that we're going to fight about. And maybe because I feel strongly about it.
I think I would agree with Frank. I think if we start to play with affordable housing, and I think we could spend all night with the public talking about that. And I think that it's been discussed a lot, it's been established. I just don't think we should mess with it.
I agree also.
Okay. Well, so a lot of points here. Are we ready for a vote on it?
Okay, so I made a motion.
So there's a motion, there's a second, there's discussion. Any other further discussion? All right, all those in favor of adding this to the warrant?
Sorry, can we wait to the discussion? So if this does not pass, then does that mean the only option that we have
To removing
to
that.
address the state requirement is to remove the,
Yes.
Or change the verbiage any way we want.
eliminate the,
Well, not any way we want, any way we want in accordance with the law.
Right, but it doesn't have to be what's
Someone else
proposed.
submits them. So
You could do a
someone else-
citizen's petition
Yeah.
on it. Somebody want to do that?
Can I make one more comment? My opinion on whether or not it goes on the warrant is, I feel that we gave Mr. McDowell our word that we would be willing to discuss it with him. And I think to take it off the table when he's not here is unfair.
You could have stayed.
No, I don't think he wanted to change he wasn't.
Well, we're not gonna speculate on what he wants.
Yeah. Right, so, all right, any further discussion on this particular topic? All those in favor of adding this to the warrant signify by saying aye. Aye. All those opposed?
Nay.
Nays are?
3, I think.
3. All right, 2, is that 5, 4, 3 against? So passes.
No, that's not.
6. 3? 6? 6 and 3.
Simple majority to put it on the warrant.
But he's miscounting, that's all.
Oh,
It's 10:15, we're tired.
All right, the third one,
Third one is the on-site apartments and removing some,
putting them at the kitchen.
the kitchen,
yep.
right?
I'll make a motion to put that on the warrant.
Second.
Second, discussion?
As you guys know, I'm against it.
Okay, got it. All those in favor, are ready to vote? All those in favor signify by saying aye. Aye. All those opposed?
Nay.
So passes. Number 4.
Adding the cultural or educational uses to the restricted recreational parcel, museum parcel, and then.
So did this go through the ZAC process?
No.
So where did it come from?
Town council.
I know town council, but why?
What was the impetus?
It's
How come
something
he
that's-
gets to add it now?
No, thank you.
It's something that's been apparently discussed by people over the last year or so and just kind of was on.
So
there.
town council just like popped it up, just like that?
Well, when I
Is that what we're
communicated about the other Osmond ideas, they said, oh, there's 3 actually, so, but the language wasn't ready for Scott.
And if we decide not to,
Someone else might submit it.
Or it could happen another year too, right?
Or citizens petition.
or a citizen's petition, but that would be wonderful by the town. Citizen's petition by the town.
Or the selectmen could submit it.
The selectmen could put it
We
on.
can kick it back to Zach. I'll put it on our work plan.
But
All right,
through the chair,
so, yes?
to Gary's earlier point, this is last minute. We just got at this meeting. Up on the other side, it is really clearly written and Lane explained it clearly what it's about and it makes sense. So I would support moving it forward.
So there's a proposal and a second on this, correct? Discussion points, Frank, I think you bring up a fair point with discussion. Any other discussion points from board members? All right, so the vote here is to add the recreational parcel and museum parcel to the warrant. All those in favor signify by saying aye.
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 All those opposed? Nay.
I know the feeling.
It's okay. All right, so that passes as well. The next one is it,
Placeholder for the proposal from Mrs. Towner.
from Ms. Towner.
This number 4, or?
This would be number
5.
5. There's a
Okay.
6th one with the streets,
This
but
is,
that's the last
these
one.
are just to bring them up to public
Public
discussion.
hearing, we're
Yes.
saving a space on the
Okay.
warrant because,
Right.
As long
So,
as- I mean, as long as Ms. Towner knows that the board could also take it off the warrant too, or not
Yes.
recommend it, so.
So she could be sure it
Not a
gets on the
done
warrant
deal.
by doing a citizen's petition. Right.
all right, so I'll entertain a motion
So moved.
to add Ms. Towner's,
I would second.
question?
it.
Okay. So there's a motion and it's a second discussion.
Yes. So you're gonna do some heavy lifting, but you're gonna provide us, Mary, the information, I guess. I'll work with Elaine.
Yeah, straight to
Yeah,
Elaine.
but
Straight to
it's
Elaine.
it's not many words.
Because February 5th is next week.
Yeah.
February 5th is next
Yeah, I gave it to you.
Tuesday.
Okay.
It's just a few words, and it's very simple. And there's already a condition there on one of the other setbacks, so it fits, there's a place to put it, right?
So through the chair, through
It's
to
not,
Gary,
it's not something that's
Okay.
foreign, it's
Get it.
not, it doesn't fit.
but to Gary, the reason is it's last minute, but it is a kind of tag along addition to what we already have in place, as far as what's in our paperwork, so it's kind of straightforward, hopefully. And we'll talk about it when she does it,
And it
if it gets approved.
wasn't really so last minute, because like I said, the.
To our schedule it is.
Right.
Yeah, well,
It did make it in through Zach, and this is the address things that are coming through Zach.
To the everyday person from, they don't understand our schedule, and that's fine, and that's something we're working with.
Got it. Amy?
So I just wanted to add that I think it's worth bringing forth to discussion at our public hearing, but I'm not feeling super confident that it will pass the public hearing and we could remove it from the warrant. So I think like like Elaine.
Prove anything.
Oh, but like
I'm
Elaine.
surprised we
No, no,
haven't got
excuse me.
more pushback on the first one.
Okay, let Amy finish here, please.
Okay,
because
but
we're
like
running late.
Elaine pointed out, if you did a citizen's petition, we could not remove it from the warrant. So if you wanted to be sure that it was on the warrant,
Yep.
you could do a citizen's petition.
Is it moment discussion? I really feel it's you know, it's just too unclear as to what's going to be said, and these are really, really specific, hard, fast regulations, And I think if we, it's just, it's almost state level regulations. And I really feel that there's not a lot of room for muddying the waters, because it could mess up, it could really mess up some of the very, very well thought out Osgood plans. And, so, I'm not
This is through the chair discussion amongst the board members.
I'm just not comfortable, I'm not comfortable with us deciding that, and I think she'd be more successful at just, putting it in as a public.
All right, we ready for a vote? All those in favor of adding it to the warrant signify by saying aye.
Aye.
All those opposed? Nay.
Nay.
Do a hands up on that
Who are
one.
the ayes?
Who are the ayes first?
3.
3. You got it, Colby? You good?
That's all you need.
All right, so that does not pass.
The third one, I'm sorry.
Oops, sorry.
I did.
This is for the yeses.
May I make one comment? Okay. Katie, you can either go forward with the citizen's petition or you can bring it to Zach, and we will discuss it, but it won't.
And the other one could have gone to Zach too, and it didn't, so.
No, I agree. So, I'm just saying those are your options.
The rules don't apply to everybody.
Through the chair.
All right, you know what? I'm not going to continue this back and
Yeah.
forth. We have another one to vote on, and we'll do that. Number 6 is the street acceptance.
So this is the only one that's not Osmond, right? So tonight, the first 5 are all Osmond.
This is straight up, right? And how would I?
No, I'm just saying,
Yeah, this is just a straight up street acceptance.
I like to
I'm
categorize
open up.
things.
I'd entertain a motion.
So moved.
So moved. Second. Second discussion.
Yes, please. Usually I like checking out the streets before we move them forward, and I'll do that before we have the open forum. But I understand because of the timing and everything that's the way it is right now, so.
And usually the winter is not the best time.
Yes, true.
All right, very good. Any other discussion?
Yeah, just other discussion. So this is the, this term I'm looking for that Ron Nation used. That's not sewage, but it's low impact lid, right? These are both lid developments?
Yep.
Yeah, so, I mean, just a comment. I do have some pictures from it, and it does take a lot of abuse, the grass, but we can talk more about the meeting, but have some input.
That's good. That's good point. All right, any other discussion? All right, ready for a vote. All those in favor of adding this to warrant signify by saying aye. Aye. All those opposed? Abstention? No, I think we're good. Unanimous. All right, so that's been accepted.
And we don't need to vote, there is a citizen's petition for a different one. We don't need to vote on that, though.
Can't do anything about
It'll be
it.
in the hearing anyway.
It's in there anyway.
Before the hearing notice will be included on the 25th, anything after that will be a separate.
Okay, so it's a self-storage facility in the industrial A district.
On South Street, yeah.
So just process-wise, if Ms. Towner was to put together a citizen's petition, then we would have a separate public hearing for that one before town meeting,
Right.
because we'll have all the other ones at this one.
Unless it comes in within the next couple of days, we'll be able to include it.
Added to this. So if it came in the next couple of days, it would be added to the public hearing that's already scheduled for the 25th. Okay.
Otherwise, it'll be March.
Yeah.
This other citizen's petition we received, that's going to be part of our public hearing? Okay.
All right. Anything else? Any other questions? Mary, thank you very much. I appreciate all the work that you and the Zach team have done.
I'm sorry, point of order. The last question, I need some clarification on Mr. Mastriani's motion with the signatures is moving forward based on the signatures, and then we discuss it automatically? I'm a little confused.
Yeah,
I'd
the
like-
citizen's petition is always in order.
Yeah, citizen petition for zoning gets forwarded to the planning board for a public hearing, which is required under the law. If it turns out that it's not proper to be voted at town meeting, it just wouldn't be voted. For example, if the people aren't registered voters.
But it's on the basis of the signatures.
It gets
Town
there.
clerk will review the signature.
It bypasses ours right here. We're still going to be talked about on the 25th.
Thank you.
Yes.
Yeah, so that's, I just wanted a little bit more clarity, like Frank. So if this goes on the warrant and it gets approved, it just goes right into our zoning without our input?
Yeah.
Okay.
Yeah.
Well, it has already.
Well, we get the input on the 25th, it goes to the 25th. We talk about it on the 25th.
It's not
we
like
can-
the
No, but we
public
can't
votes.
vote it yes or no, it automatically goes.
We can
can
give
support it or
our
not support it.
recommendation.
You'll make a
Right,
recommendation.
right, right,
Recommendation.
right.
Town meeting ultimately votes on all.
Town meeting ultimately.
Ultimate votes, correct, yes. Okay, got it, thanks.
Can't remove
Okay,
it.
it's gonna be on the warrant, one way or the other.
It's just a one-off that we haven't had a lot of experience in.
Yours is a high bar.
Yes, it is. All right, so the last order of business, I think, is just to approve the minutes from the meeting on December 17th.
I'll move the minutes.
Second?
Moved and seconded. Any discussions, clarifications? All right, we're ready for a vote. All those in favor signify by saying aye. Aye. All those opposed? Motion passes.
Again, Kobe is batting 1,000.
Kobe?
The rest of us.
Getting out of the park, right.
Be different for the 14th.
Unless there's anything else, I'll open up a motion or entertain a motion to
So
close the
moved.
meeting.
Second.
Something
No,
else?
no, I was just gonna dismiss.
Yep. Oh, yes, Katie?
You had an item on here for correspondence and future agenda items, and I had something that kind of applied to both, if I may.
Sure, I missed that, but absolutely, come on up.
I know it's on your agenda.
As I mentioned, I apologize, I missed that.
Oh, okay.
The trail committee, we.
Okay, so I just wanted to bring up, I emailed the board last week about a concern I had about, I had made a FOIA request about all of the drainage plans that were there was supposed to be a plan to reconstruct the Wilson Street drainage structure that was not properly designed or built, and that hasn't happened. So I made a FOIA request for the information and the plans, and I got all that information, and I read through it last weekend, and or 2 weeks ago, and what I found is that there was a plan that was put through in November. This was all supposed to be done before the winter, but the plan wasn't even ready for sign-off until November. And then when it was put out for bid to construction, the guy who buys the material came back and said, hey, this costs more than the previous design, so how about we don't implement the engineered design? How about we just don't, we eliminate the requirement for the biofilm material? How about that? And then it'll cost less. And that was administratively approved by the land use office. So my comment and my concern that I emailed, that I don't know if it was distributed to you guys or not, is that I was very disappointed that this engineered design that we went through, and we went through all of the reasons why the first one was not correct. It's because the engineering was not done. So this time around, we did the engineering, but then we did an end-around play to say, well, we're still not going to do it anyway, because we're going to administratively say that we don't have to, we can change the design. A non-engineer can change the design, and we'll save money. We're pleading poverty. We don't, for whatever reason, we're not going to do any analysis to say why it's okay not to build the correct design. We're just going to change it, and that'll be that. So I was disappointed in that, and I...
Through the chair, I think we understand what you're saying. Can we talk about options?
So, I'm open to discussing the options. I haven't seen any documentation.
I was just looking to see if
Well, that's why I was just wondering if we could
So it's
maybe
not
get
on the
that.
agenda, so the board can't really discuss it this time.
I mean,
Put it
we-
on a future agenda.
I was gonna say, if we could-
I did ask that it be discussed, brought up to the board. Like I say, I submitted my,
They responded to you.
I didn't see the response. I saw a response to something else.
I responded to you.
Okay, well, I didn't see it. But I would like it discussed,
So I think if we probably get it on the next agenda, next meeting, to be able to have a formal discussion where we can review materials. I think that's probably the best venue. for this type of discussion. Otherwise, we're kind of flying blind right now, although there's been communication back and forth between you and Elaine. Just,
Yeah, that'd be great, because I'd like to see it built properly and not changed for a, what do we call it, arbitrary reason. A-
Through
so
the
is
chair.
the next meeting, we can kind of get it on the
And-
March
I think
7th?
I just want to comment, it's a legitimate concern, and I think we should add it to the agenda, so I think we hear you.
March 11th meeting, Kobe, if we can get, some 15, 30 minutes of time.
Thank you.
That'd be great. Thank you, Ms. Towner. I did neglect a couple of the items to be considered. I don't know if we need to nail them now, the trails coordination and...
Is there a deadline for that, or can we put that off?
There's no deadline.
Yeah, I think we should adjourn and
Okay.
leave it on the
Yeah.
bottom of the
All right,
agenda
we'll leave
for
it there.
future
And I
meeting.
think that's the only other thing.
Through the chair, do those items, I just closed my agenda, so does it say if time allows to discuss these
It
items?
does say at any time, it doesn't say business that can be considered by the board at any time during the meeting.
I wonder if we should say if time allows on our future.
Mr. Chair, can I
Just to dot
throw
I's
in two
and cross
updates,
I's.
something quickly?
30 seconds.
Okay, first is tomorrow's Board of Selectmen meeting. They'll be closing the Center School Reuse Committee, so that will be completely done. And then secondly, I attended the last Board of Selectmen meeting on Friday, and they had a special occasion for former planning board member Sandy Altamura, who has moved out of town, but they gave her a special plaque, and it was a very nice event.
Why was there a meeting on Friday, Dean?
Because of the special town meeting.
Town meeting warrant.
It's a daytime meeting.
I wish we had been invited.
I was.
Very good.
I wish, to that point, I wish we had better communications pushed to us, instead of having to go find out when things are, I think,
But it's awesome that they recognize Sandy.
it always seems like I'm missing upcoming events.
Huge contributions.
Yeah. That's very
True.
good. Yes.
True. I don't know the solution, but it was just
I
a
have a
wish.
suggestion. E-hop.
Now I'll entertain.
Weekly memo.
To
Yeah.
close
Oh,
the...
papers are available to be taken out for the positions, the open positions on the planning board. And I would personally like to encourage everybody who is still here to stay here if they would like, because this is
One person did pull papers.
has somebody pulled papers?
I have pulled papers.
Very nice. I kind of heard that through the room.
So Fran, before you adjourn, just quickly, two things real quickly. One is a request to Elaine, and if it's not too much trouble, could we get the package with the agenda separate from the big package? Because it's just nice to pop into the agenda real quickly versus taking like a minute and a half to try to open.
So on the
That's
town
what-
website, it's both ways.
They're both attached to the calendar.
To the calendar, but not
Would
to
you
the
like us to
email.
send you the agenda separately?
Yeah, I asked Georgia, and she did that for us, and it was really nice. I'm spoiled by her. Yes. And secondly, just a quick note that I sent an email to Fran and Elaine and Ariel, just to add to the item, future agenda item, the reconstruction of the 495 and I-90 interchange, because I don't know if anybody's heard, but the what's the word for them, sky passes or whatever, flyovers. They're talking about building flyovers that are 50 feet tall, 55 feet tall, which is 5 stories, so future agenda item.
What's a flyover?
Instead of a clover leaf, it's a road that goes up and over
Holy
everything.
smokes.
Wow.
We don't have that anywhere in New England that I
It's like
think
they have
of.
those in LA, yeah. It's just
Yeah,
the same thing.
right. So anyway, just a heads up that hopefully we'll discuss it.
It's a pretty,
All right.
Thank you.
I will entertain a motion, no worries, very good, to close tonight's meeting.
Second, motion.
So moved, seconded, all those in favor?
Aye.
Yes, apologize, guys, I was not very good. That's why I'm the vice chair only.